So I'm going to give them their numbers now. I'll have Tracy, you deliver the numbers to them.
Okay, guys, good morning. Court's just getting started. They're getting ready to assign jury numbers. So basically, juror number 1, juror number 2, all of those things. Read the instructions. Yesterday, the prosecution closed. Ma'am is getting up saying something. Okay, we're getting into it. So I'll jump in every so often,
She's just
but
handing in the stuff, as far as I
I'm
know.
gonna kind of.
But if she starts to bring them out, I'll send them back.
Good morning, everyone. Welcome, welcome, welcome.
Has everyone looked at the instructions?
Yes, sir.
Is there any objections by anybody regarding the instructions?
There are.
Okay. By the way, we're back on the record. State of Florida versus Susan Lorincz, 23 C 2236. Is it possible I can maybe do this another time?
Yeah.
Okay. Yeah, maybe like later, much later. That's okay. Thank you. 23 CF 2236. So everyone's looked at the instructions. Is that correct?
Yes, sir.
Yes, sir.
Does the state have any objections?
No, Your Honor.
Any additions?
No, Your Honor.
Does the defense have any objections?
No, sir.
Any additions?
No, Your Honor.
Okay. So I'm going to read to them in the order that we previously said. So the last thing I read will be the justifiable use of deadly force instruction. And then I'll read to them the closing argument instruction. So, Mr. Buxman, you're giving the closing argument?
I am, Your Honor.
Ms. Sizemore, you're giving the closing argument?
Yes, sir. I would ask that we take a short break after Mr. Buxman is finished, just so I can set up my stuff.
Yeah, no problem. We'll take a break after Mr. Buxman finishes.
Last night I was thinking about how they have the door right there in the courtroom, and let's see what she has to
The
say.
argument you want to make?
Judge, there's no additional argument, just the argument that I made previously.
Sorry, I can't hear you.
There's no additional argument, just the arguments that were previously made.
Okay. I remember the arguments that were made. I reviewed the case law you submitted. I'm going to deny the motion for judgment of acquittal on the same grounds I denied it at the middle of the trial.
Yes, sir.
All right, thank you.
Sis is trying the judge. Okay. I hope the prosecutor puts the door in front of the jury and stands behind it and gives a really good visual of that. I don't know if that makes, I don't know. It came to me last night. Like, he should give the whole closing argument from behind the door.
Whether anyone has influenced them or they've spoken to anybody, I'm going to explain to them the numbering system, and then I'll read the instructions. When we're done with everything, then I will excuse the 2 alternates. However, I'm instructing everyone not to have any contact whatsoever with the alternates. Please don't speak to them. Please keep them in the same manner they were before. In other words, don't acknowledge them. I'm just going to excuse them from the courtroom. I'm going to instruct everyone in the courtroom not to have any contact whatsoever with the alternates. Don't ask them a single question, okay? I'm going to send them home and instruct the alternates not to look up anything about the case or discuss anything about the case until they've heard that the trial is over. Because there's always a possibility an alternate could be brought back into deliberation. So that's why I'm instructing everybody. An alternate, just so you know, if something happens to a juror in deliberations, the alternate could be brought back in. But if someone talks to that person, then I can't bring the alternate back in. So I'm instructing everyone to leave the alternates alone. We'll get them back to their cars and then let them go home. Okay?
Yes, sir.
All right.
So I guess they'll be notified if they're needed back, or they'll be notified of the verdict, because how are they going to hear that the verdict has been achieved if they're not paying attention to the case. That's all I'm saying.
Bring it back, please.
Once again, for the record, I would use the defendant is dressed in civilian attire as always, and not handcuffed.
That's correct. And she is here and present. Thank you. Welcome back, ladies and gentlemen. Have a seat, please. As I've done before each day, I just want to ask you the same questions. By show of hands, has anyone contacted you about this case or said anything to you in your presence about this case? I see no hands. Have any of you contacted anyone else about this case or spoken about this case with other people? I see no hands. Have any of you gone online and looked up anything about this case in any sense whatsoever? I see no hands, and I appreciate it. The bailiff has given each of you a number, piece of paper with your name and number on it. That number will be used by you if jurors have questions or anything else. We're going to refer to you by number. So either keep your piece of paper or memorize your number, which shouldn't be that difficult. However, when final deliberations end, the verdict form has to be actually signed by the person. Don't sign with your number, okay? And we have a list of whose number, but otherwise you do have to sign it, okay? If you send a note to us, just use your number, all right? Listen carefully. I have your final instructions. I'm going to give you the first part of these instructions, which mainly deal with the offense and the defenses and all the elements that you need to know to understand the charges. Then they'll have their closing arguments. And the last part of the instructions really deal with how you go about your deliberations, okay? So please listen carefully. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Susan Lorincz, the defendant in this case, has been accused of the crime of manslaughter by use of a firearm. Susan Lorincz is accused of manslaughter by use of a firearm. Manslaughter is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that Ajike Owens was killed by Susan Lorincz, you will then consider the circumstances surrounding the killing in deciding if the killing was manslaughter or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause the death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Susan Lorincz may be found guilty of manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Ajike Owens is dead. 2. A. Susan Lorincz intentionally committed an act or acts that caused the death of Ajike Owens. Or B. The death of Ajike Owens was caused by the culpable negligence of Susan Lorincz. Every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is the equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. Aggravation of an offense by using a firearm. If you find that Susan Lorincz committed the crime of manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, she personally used a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to, or may readily be converted to, expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find that Susan Lorincz committed the crime of manslaughter, but you are not convinced beyond a reasonable doubt that she personally used a firearm, you should find her guilty only of manslaughter. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Justifiable use or threatened use of deadly force. It is a defense to the crime of manslaughter by use of a firearm if the actions of Susan Lorincz constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Susan Lorincz does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. The law on the justifiable use of deadly force is as follows. If Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent A, imminent death or great bodily harm to herself, or B, the imminent commission of burglary, murder, or aggravated battery against herself. The crime of murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrative of a depraved mind without regard for human life. The crime of burglary is defined as entering a structure owned by or in the possession of another with the intent to commit a crime therein. However, the crime intended cannot be burglary or trespass. Structure means any building of any kind, either temporary or permanent, that has a roof over it, and the enclosed space of ground and outbuildings immediately surrounding that structure. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. The crime of aggravated battery is defined as intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to another. In deciding whether Susan Lorincz was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Susan Lorincz is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself when using defensive force that was intended or likely to cause death or great bodily harm to another if A. The person against whom the defensive force was used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling or residence. And B. Susan Lorincz knew or had reason to believe that an unlawful and forcible entry or unlawful, let me reread that. And B. Susan Lorincz knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. A person who unlawfully and by force enters or attempts to enter another's dwelling or residence is presumed to be doing so with the intent to commit an unlawful act involving force or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides, either temporarily or permanently, or is visiting as an invited guest. If you find that Susan Lorincz, who because of prior threats or difficulties with Ajike Owens, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Ajike Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. If you find that at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Ajike Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed that it. Let me reread that paragraph. If you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Ajike Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of Susan Lorincz and Ajike Owens. Both the state and defendant have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. I just want to remind you that I will be giving each of you a copy of these instructions to take back with you when you deliberate. Mr. Buxman. Yes, sir.
May I have the access to the TV runner?
You ready to go? You ready for it?
Yes. This case basically requires you as a jury to answer one question. Was it reasonable to shoot through a closed, locked, deadbolted metal door at someone who's banging and yelling on the other side? That's the ultimate question in this case. The evidence in this case that you've heard for the past several days has proven beyond any reasonable doubt that the defendant's actions were not reasonable that night. The judge just read the law to you that's applicable to this case, and it is that law that guides your decision in this case. It is that law that you must follow. It is that law that we as a society have agreed to live by, and you, by taking your oath as a juror, have agreed to follow. And that's the law that should guide your entire analysis in this case. As you heard, the defendant is charged with one count of manslaughter. And in order to prove manslaughter, the state has to prove the following two elements beyond a reasonable doubt. Number one, Ajike Owens is dead. That is not in dispute. That was agreed by the parties. I'm not going to spend any more time on that. That's been proven beyond any doubt. 2, the state has to prove either that Susan Lorincz intentionally committed an act or acts that caused the death of Ajike Owens, or B, the death of Ajike Owens was caused by the culpable negligence of Susan Lorincz. The state only has to prove A or B, but the evidence in this case has proven beyond any reasonable doubt both of those. Let's talk about A first. That the defendant intentionally committed an act or acts that caused the death of Ajike Owens. There is no question in this case that the defendant was the one that fired the gun that shot and killed Ms. Owens. She was the only one in the apartment that night. You heard crime scene investigator Catherine Medina, who processed the inside of her apartment, went into that bedroom and found that .380 Remington firearm in the trash can beneath that .22 Ruger firearm. Catherine Medina also found the spent shell casing that was found on the kitchen counter. Dr. Norford, the medical examiner, removed the projectile from Ms. Owens's body. And you heard from Florida Department of Law Enforcement analyst Jamie Williamson, who said she took the firearm that was found in the defendant's residence, compared it to the spent shell casing found in the kitchen, and determined that that casing was fired from the defendant's gun. She also examined that projectile recovered from Ms. Owens's body and compared it to the .380 Remington firearm, the defendant's, and found that the projectile in Ms. Owens's body was fired by the defendant's gun. Finally, the defendant admitted during her interview that she was the one that fired that gun. She also admitted that the act of pulling that trigger and firing that gun wasn't intentional. It wasn't an accidental situation. It wasn't a situation where she slipped and fell and the gun accidentally went off and shot through the door and struck Ms. Owens. That's not what we have here. She intentionally fired it. There's no doubt the defendant intentionally committed an act which caused the death of Ajike Owens. And we also know that Ms. Owens died as a result of that gunshot wound. The state's proven this beyond any reasonable doubt. You heard the judge read an instruction. You may be back there thinking, well, what if the defendant didn't intend to kill Ms. Owens? Well, the judge has told you that that is not an element, that's not a requirement for the state to prove in a manslaughter charge that the defendant intended to kill Ms. Owens. She's not charged with first-degree premeditated murder, which would require an intent to kill. She's charged with manslaughter. The judge told you that in order to convict of manslaughter, it's not necessary for the state to prove the defendant had an intent to cause the death. We'll get into what the state only has to show that the act was not merely negligent, justified, or excusable, and we're going to get to those terms in a few minutes. Because element A of part A of element 2 has been proven beyond any reasonable doubt, there's no even need to get to B. However, the evidence has also proven that the death of Ajike Owens was also caused by the culpable negligence of the defendant. The judge read to you a long instruction about culpable negligence, told you that each of us has a duty to act reasonably towards others. In order for negligence to be culpable, it must be gross and flagrant. It has to show a reckless disregard for human life or the safety of people exposed to its dangerous effects. It has to be committed with an utter disregard for the safety of others. The evidence has proven that the defendant did act with utter disregard for the life of others. She pointed a loaded firearm towards a door, towards a person that she knew was there on the opposite side of the door, and intentionally pulled the trigger. That shows a reckless disregard for human life. It's an act which she must have known or reasonably known would cause death or serious bodily injury if that projectile struck somebody. The evidence has proven beyond any reasonable doubt that the act of firing that gun constitutes culpable negligence. The crime of manslaughter has been proven beyond any doubt whatsoever, ladies and gentlemen. The question in this case lies with whether or not she was allowed to shoot and kill Ms. Owens under these circumstances. The law says that in certain circumstances, a person cannot be held liable or responsible for shooting another person. And the first situation is if the killing was excusable. The judge read to you this instruction a few minutes ago. I'm not going to read the whole thing, But in order for a killing to be excusable, the killing in each of those three situations has to be committed by accident. And we've already discussed that this was not an accidental discharge. It's not a situation where she was playing with the gun and it accidentally went off and shot through the door, or she dropped it. This was an intentional act. So excusable homicide is not relevant in this case. Another way in which a person could not be held legally responsible for killing another is if the killing was justifiable. You heard Judge Hodges read a few minutes ago that the killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant or commit a felony in any dwelling house in which the defendant, was at the time of the killing. That is the general instruction on justifiable homicide. The judge read to you a longer, more detailed instruction, which is what I'm going to go over now. Judge Hodges explained to you that if the defendant was in a dwelling or residence in which she had a right to be, she had the force if she reasonably believed that such conduct was necessary to prevent either A, imminent death or great bodily harm to herself, or the imminent commission of a burglary, murder, or aggravated battery against herself. That first sentence there, if she was in a dwelling or residence in which she had the right to be, she had no duty to retreat. That applies in this case, ladies and gentlemen. The defendant was in her own home. The law accounts for that because people do have a right to be in their own home and be safe in their own home. That applies in this case. The law does not require her to jump out the back window and retreat in order to avoid this because she is in her own home. She doesn't have to do that in order to claim that she acted in self-defense. Now, her actions inside of her house and what she does during this period of time is relevant to look at the reasonableness of her fear and the reasonableness of her actions and decision in making and shooting. But she is not required to try to jump out a window to avoid this before she can claim self-defense. The crux of this case, ladies and gentlemen, is whether at the time she fired her gun at that closed, locked, deadbolted door, did she reasonably believe that her conduct was necessary to prevent imminent death or great bodily harm against her, or the imminent commission of burglary, murder, or aggravated battery. The instructions that the judge read to you gives you an explanation of what burglary, murder, or aggravated battery mean legally. And I'm going to go through those later on. He read them to you, so I'm not going to go over them again right now, but we're going to address those later on. The judge also explained to you that in deciding whether the defendant was justified in using deadly force in firing that gun, you have to consider the circumstances under which she was surrounded at the time she chose to fire. Judge Hodges explained to you that the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real the defendant actually believed the use of deadly force was necessary. Well, what does it mean by the danger need not be actual? Well, if the bailiff here and I are getting into an argument and I start getting heated, I start walking towards her and I pull out a gun and she pulls out a gun and shoots and kills me, but my gun was a fake gun, my danger to her wasn't actual. But all the circumstances surrounding it made her think that it was. So the actual danger need not be actual, but the defendant actually had to reasonably believe that the use of deadly force was necessary to prevent an imminent harm to herself. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. The standard by which you review this is based on whether a reasonably cautious and prudent person under the same circumstances the defendant would have felt the danger was necessary. You take a normal, average, everyday person and ask yourself, would that normal, average, everyday person under these circumstances have believed that it was necessary to use deadly force to prevent the imminent harm to themselves or the imminent commission of a burglary, murder, or aggravated battery? I've used the word imminent many times because that's in all of these definitions, and that's very important. It's not that something bad could happen in the future or something may have. That something bad has to be imminent, immediate, about to happen. So let's start with whether or not the defendant reasonably believed that her firing the gun was necessary to prevent imminent death or great bodily harm to herself. What were the circumstances she found herself in at the time she chose to pull that trigger? Because that's the relevant time. When she makes that decision to pull that trigger, what are the circumstances surrounding her? That's what the law focuses on. Taking a step back though, we know that there have been past issues between the defendant and Ms. Owens. We've heard about a couple issues during the testimony and the evidence that they had some conflict in the past. That information is relevant to you, could be relevant to you to consider, because those past contacts between the defendant and Ms. Owens could factor into the reasonableness of her decision in pulling the trigger. They may not. But the judge read to you, if you find the defendant who, because of threats or prior difficulties with Ms. Owens, had reasonable grounds to believe she was in danger of death or great bodily harm at the hands of Ms. Owens, you may consider this fact in determining whether the defendant's actions were those of a reasonable person. I want to talk a little bit about those prior issues. We know that these prior run-ins were the result of the defendant acting out or doing something towards the victim's children, Isaac and Israel. And at the time, we heard that Isaac was about 12 years old, Israel was about 9 or 10 years old. We heard that the defendant complained about the children, complained about them playing in this field, this open lot next door to her house. You heard that these children would play in that open field. They played football, they played some bottle game and some running around, what kids do. They weren't breaking into cars, they weren't vandalizing.
So ruled. Go ahead.
They weren't causing problems, vandalizing things, they were playing. And you heard from Frank Colon, who told you he was often out there playing with the children regularly to make sure they behaved. But as children do when they're playing, especially in groups, the children got loud. The children yelled and screamed and played, did what kids do. The defendant, the evidence has shown, didn't like that. She told him, the detectives in the interview, she worked from home. The loud noises interfered with that ability. She didn't like it. She complained to Charles Gabbard, her landlord, and Charles Gabbard, in response, in order to pacify her and appease her, got some no trespassing signs, those little signs that you get from Lowe's or Home Depot, and put them in the ground. She complained to the police about the children when she would call, complaining that the children were too close to her property or trespassing on her property or leaving things on her property, toys, and that they were loud. It's important to note that Charles Gabbard owns the property the defendant lived in, but he does not own that open field where the children played. Charles Gabbard has no ability to tell those children don't play there or tell the children to be quiet, and neither do the police. You heard on two prior occasions that there were some prior difficulties between the defendant and Ms. Owens. You heard on one occasion, which happened February 25th of 2022, about 16 months prior to the shooting, that the defendant was again upset about the children playing, being loud, doing what they were doing. And you heard from London Remy, the 13-year-old girl that testified on the first day of this trial, that Ms. Owens walked over to the defendant's area, and there was an argument between the defendant and Ms. Owens. Ms. Owens went over there to tell the defendant to stop yelling and treating her kids the way that she was. There was an argument, and Ms. Owens pulled the no trespassing sign out and tossed it at the defendant as she was walking away. You heard London Remy talk to you about that. And she explained and even demonstrated how Ms. Owens took the sign and tossed it as she was walking away. And that sign hit the defendant in the leg. Was that the proper way of probably handling the situation by Ms. Owens? Probably not. But what's important to know is there were no punches thrown. Ms. Owens didn't run up and attack the defendant, didn't punch her in the head, knock her down, kick her, didn't, bust into her house or anything like that. Ms. Owens said what she had to say, tossed the sign, and walked away, leaving the confrontation. The defendant called 911, the emergency line. The officers came out, talked to everybody, and no arrests were made. On another occasion, December 22nd of 2022, about 6 months before this crime, the defendant was again angry at the children for being loud. Obviously, the children told their mother because, again, Miss Owens came over to the defendant's property and told the defendant not to yell at the children. We heard from Deputy Kinsey, who spoke with Miss Owens, and Miss Owens told Deputy Kinsey, I walked over there with my child and wanted to talk to the defendant and deal with the situation. According to the defendant, the victim told her that if you yell at my kids again, I'm going to drag you out and beat your butt, basically. But remember in the defendant's second interview that you heard with the detectives, she was specifically asked if she remembered any kind of threats like that. And the defendant said she didn't remember anything. So either Miss Owens never made such a statement or the statement wasn't so significant such that the defendant even remembered it to talk to the detectives about it when specifically asked. And we also know that the defendant, moving ahead to the night of the shooting, the defendant tells the detectives that Miss Owens came over and said, I'm going to effing kill you over and over again. No one else heard that. You heard from Jared Gardner, you heard from Gabriel Rodriguez, who were right there. They said she never said that. So back to February of 2023. We know that Ms. Owens was upset about how the defendant was talking or treating her children. Ms. Owens walks over to the defendant's property. They have this argument, disagreement, whatever you want to call it. There's no violence. There's no punches thrown. Ms. Owens doesn't knock the defendant down and kick her and beat her. She doesn't try to break into her house, shatter her sliding glass door to get to her, nothing. It's a verbal argument, and the verbal argument ends when Ms. Owens walks away from the situation and goes back to her house. The defendant again calls 911. The police come out. They interview everybody. No arrests are made. As I said earlier, you can consider these prior difficulties between the two in determining whether or not they contributed to the defendant's decision to fire that gun that night on June 2nd, 2023. I submit to you that these two episodes, one of which happened about 16 months before the shooting, one happened about 6 months or so before the shooting, involved no violence except for the tossing of a sign, a flimsy Lowe's no trespassing sign. They didn't involve the defendant or the victim trying to break into the defendant's house. Didn't involve Ms. Owens beating the defendant up or causing her any physical injuries, and were resolved when Ms. Owens walked away from the confrontation. Now, it's interesting in her interview, in the defendant's interview, that she described an incident that happened about 2 months before the shooting on June 2nd, after the sign throwing incident, after the second incident that happened in December of 2022. She described an incident that happened about 2 months before the shooting. Now, the defendant in her interview tried to explain how this sign throwing incident and this other incident caused her such terror of Ms. Owens, such fear, such panic, because Ms. Owens was so violent that contributed to her, the reasonableness and why she decided to fire the gun. But let's talk about what the defendant said in her interview about the incident that happened 2 months prior to the shooting, after these other things. She's talking to the detectives about the sign throwing, or about this incident that happened 2 months before, and she tells the detectives, and one time she was talking to the neighbors, meaning the defendant, or meaning Miss Owens, and she said, oh, that bitch over there is crazy, I'm not going, sorry. I walked over. I said, what is your problem? And she just went on a tirade. She tells the detective, I walked over and said, what is your problem? The defendant admitted that she was the one that walked over and confronted Miss Owens about Miss Owens telling a neighbor that the defendant was a crazy bitch. And she told the detectives further that she was actually over by Miss Owens's driveway when she confronted Miss Owens. Does that sound like the actions of someone who was so terrified because somebody tossed in a trespassing sign and someone came over and had an argument with her earlier? Does that sound like somebody who's so afraid of this woman that she's going to walk up to this woman, confront her in her own driveway? Or does that sound like someone who is angry at Miss Owens and has no problem initiating confrontation? The defendant also explained that during this same incident, two months or so before the shooting, that Miss Owens accused her, the defendant, of using racial slurs towards her children. The defendant during an interview explained, look, I told her I didn't do that. She kept insisting I did. And the defendant said, I eventually just said, I'm sorry, to diffuse the situation. There is probably nothing more infuriating to an African-American woman.
Objection, improper argument.
So overruled.
There is probably nothing more infuriating to an African-American woman for someone to believe that someone used a racial slur towards her children. But what does Miss Owens do when she thinks this is what happened? She doesn't go and attack the defendant, she doesn't go over and beat the defendant up. She doesn't go and attack Miss Lorincz, push her down, and say, this is what you told my children. She goes and she has an argument. And Miss Owens doesn't resort to violence. Miss Owens walks away. Miss Owens, if she wanted to, had every ability to attack the defendant for that. But she didn't. She had every ability because even then, there wasn't a closed, locked, deadbolted metal door between them. Despite not having that barrier, Miss Owens did not do anything violent towards the defendant. Instead, she walked away without incident. Which brings us to June 2nd, 2023, the day of the shooting. We saw videos taken from the defendant's cell phone during the couple hours before the shooting happened. They showed the children playing in that open field. You saw Frank Cologne out with the children one time in one of those videos. And in one of those videos, taken at 8:49:51, we see Israel waving past the trespassing signs on her property, waving at her. Once again, the defendant was angry because the children were being loud and it was bothering her. And Israel went past the no trespassing sign. And you heard from Uriel Rodriguez, who said, yes, in fact, that night, Israel did go past the no trespassing sign. We saw that in the video we just looked at. We heard from the defendant's 911 call in the interview with the detectives that there was some altercation between the defendant and Miss Owens's children. It involved a tablet, roller skates being thrown, an umbrella being shaken, something. The facts of that altercation really aren't important or relevant. What's relevant is that is the catalyst. That is what causes the children to go and tell Miss Owens. And that's what causes Miss Owens to come over and once again deal with an issue regarding the defendant and her children. We heard from the 911 call that the defendant made, the first 911 call before the shooting, as she acknowledged there was an issue with the children. She acknowledged that she threw some roller skates. She acknowledged and told the 911 operator that the child accused her of stealing the iPad. We heard in the 911 call that in the interview that there was something involving shaking an umbrella as well. So we know that the defendant got into some sort of argument or something with the children, which caused the children to go talk to Miss Owens, their mother, and causes Miss Owens to come over to deal with it. You heard from Jesse Newbanks, the Marion County Sheriff's Office digital forensic examiner who examined the defendant's cell phone. And going into the logs of the cell phone, we know that the defendant first made that first 911 call that we heard at 8:54:09 p.m. And you heard her on that call. That was played earlier. You heard her. She was angry about the children trespassing, angry about that 9-year-old stepping onto her property, angry about the children leaving things in her area. She was angry the kids were being noisy. And she admitted to throwing the roller skate like we saw in the photo a few minutes ago. She told the 911 operator that she was sick of the children. Her words were, "They are bothering me. They won't effing stop." She wasn't afraid. She was angry. You heard the tone of that 911 call. The 911 call, an operator asked, are you in danger? And she said, no, I locked my door. She locked her metal door. We know from her 911 call, the main lock was engaged. We know from her interview with the detectives, the deadbolt was engaged. So at this time, she is behind a closed, locked, deadbolted metal door, standard metal door, about 1 3/4 inches thick. She's behind that in her concrete block home. Now, let's take a pause from June 2nd. You heard some information about the door jamb having some prior damage to it. And we saw photos, the state introduced photos of that door jamb and the prior damage. We heard from the landlord, Charles Gabbard, who said, yes, that door about a couple months earlier had some damage to it. I went and repaired it. He told you he replaced the strike plate of the lock. He replaced the strike plate for the deadbolt. He drilled those things into the door frame and it was secure. He used some wood putty to further secure it. And the only thing that was left was some cosmetic damage that didn't affect the integrity or the stability or the durability of that door. He told you that when he left, the defendant was content with his repairs, except for the cosmetic damage, which he said, I'm going to come back and make it look pretty. But that door was secure. There was no concern at all that that door wasn't going to hold up if someone banged on it. So we talked about the first 911 call was made at 8:54:09 p.m. And based on Jesse Newbanks' analysis, that call lasted 4 minutes and 55 seconds, which means she hung that phone up at 8:59:04. At 9:01 and 37 seconds is when the data on her phone says she picked up the phone again to call 911 after the shooting happened. So whatever happened with Ms. Owens coming to the door, banging on the door, the defendant going in to her bedroom, getting the gun, coming out, aiming at the door, shooting, and then her getting her cell phone and making a call took 2 minutes and 33 seconds. Not the 10 minutes like she told the detectives, 2 minutes and 33 seconds. So again, the evidence has shown that before she makes the second 911 call, Ms. Owens walks from her house across the street to the defendant's house to deal with the situation involving her children. Witnesses said she walked over there with purpose. She was mad, no question. Jared Gardner told you that he heard Miss Owens say, after she's banged on the door, something to the effect, out here, bitch, or bitch, open the door, something to that effect. Jared Gardner told you he never heard Miss Owens say anything like, I'm going to effing kill you. I'm going to break down your door. I'm going to go in your house. He didn't hear anything like that because those statements weren't made. He heard Miss Owens tell the defendant, come outside. You heard from Uriel Rodriguez, 12-year-old Uriel Rodriguez, the second witness we called. He told you he saw Miss Owens walk across the street, saw her walking with a purpose, saw that she was angry. It was clear how she was walking, saw she didn't have anything in her hands. He heard Miss Owens say, come out. And he said she used the B word and the F word, consistent with what Jared Gardner said. So he too hears Miss Owens say, come out, bitch. Uriel Rodriguez said he never heard Miss Owens threaten the defendant, say, I'm going to F and kill you, I'm going to bust in your house, anything like that. It was come out. Ms. Owens made it clear to the defendant that she wanted the defendant to come out and deal with this situation. If Ms. Owens wanted to get into that house, all she had to do was take something from the patio, that little Santa thing that was sitting there, throw it through the sliding glass door, shatter the door, and get in there. She didn't do any of that because her goal was not to get in the house. It was to get the defendant to come out and deal with the situation with her children. Even in the defendant's interview with the detectives, she was asked what was the first thing that came out of Miss Owens's mouth. And the defendant said, Miss Owens first said, I want to speak to you because you're talking to my sons. I don't like the way you're talking to my sons. First thing out of her mouth deals with her sons. First thing out of her mouth is not, I'm going to bust in your house and I'm going to kill you. It's, I want to talk to you about my sons, just like the last times. You heard from Yvonne Costa, who's the neighbor who had the joining wall to the defendant's apartment. She told you that she heard arguing, loud arguing, and then she heard a door slam. Clearly, this was the defendant slamming her door after she was arguing with the children, because Yvonne Costa said a few minutes later is when she hears the pounding, and the pounding was loud. There's no doubt about that. It was loud enough to shake the wall between the two of them that they share, and maybe even rattle a mirror. It was loud, but it wasn't banging hard enough to damage the door. There's no dents. There's no major problems with the door. No damage to the doorknob as if someone was trying to beat on it and break the doorknob off to get in there. She was banging hard like law enforcement officers do when they come to a door and say, Marion County Sheriff's Office. And in fact, the defendant actually told the detectives she initially thought it might be the law enforcement coming. Why? Because she just called them and knew they were coming. She knew they were coming before she fired the shot. Everyone then, after the banging, hears the shot. You heard the interviews the defendant gave and the 911 calls. The defendant never said that Miss Owens was rattling her doorknob, shaking the doorknob as if she was trying to get in. She was specifically asked during the second interview, did she ever try to open that sliding glass door or open the door handle or anything like that? Or was it just pounding? The defendant's answer was, I just remember her pounding and pounding. You also heard in the interview that the defendant gave that the sliding glass door was further secured by a wooden stick in the track, so the door couldn't be opened. It was locked, the door couldn't be opened because of that wooden stick. The defendant never told the detectives during the interviews that Miss Owens was trying to open that sliding glass door, that she was banging or jiggling on the doorknob trying to get in. Never told them that she was trying to break her window or anything like that. Rather than wait for law enforcement to arrive, because she knew they were coming, because she called and they told her that law enforcement was coming, she went into her bedroom and grabbed her gun. She doesn't grab her phone, which she just had in her hand 2 minutes earlier, to call 911 again. She goes in the bedroom and grabs her gun. She goes back into the family room. She approaches the door to the point where she says she reached that kitchen table. She doesn't fire a warning shot through the door or in the air, into the ground, anything like that. We heard her in her first interview say she never intended to kill Miss Owens. Well, look at the placement of the shot that she fired. She took aim. She leveled the gun at the door. She aimed directly where a person would be if the person was knocking on the door, at a height consistent with where Miss Owens would be, and pulled the trigger. She didn't fire over and over and over again. She didn't unload her magazine as if she was in a panic. She fired one controlled, precise round into the door at the exact place a person would be if they were knocking. Then she had the presence of mind to go back into her bedroom, put that .380 Remington back in the trash can, underneath the .22 caliber Ruger that was found, because remember, CSI Medina found the .380 gun, the gun that used to fire the bullet in this case, beneath the .22 caliber Ruger, the little plinker. And then she has the presence to call 911. So now that we know what the evidence has shown, let's go back to the instructions that we looked at earlier. The circumstances that she found herself in when she fired that round were that she was angry at Miss Owens' children, such that she called 911 on the children. That an angry mother was banging on her door, yelling at her to come outside. That she is behind a closed, locked, deadbolted metal door, and she knows law enforcement is on the way. She goes into her bedroom, she grabs her gun, walks back to the living room, walks towards the door, fires one precise round in the exact location where a person would be. Those are the circumstances by which she was surrounded when she made that decision to pull the trigger, at the time she decided to use deadly force. There was no imminent danger whatsoever when she fired that gun. Ms. Owens had not broken down the door. She hadn't gained access to her house. She hadn't shattered the sliding glass door to get in. Ms. Owens was banging on the door, telling the defendant to come out. A belief that there was an immediate or imminent danger such that deadly force was necessary at that time was simply unreasonable, because there was no imminent danger. And that word imminent is very important. It's included in the law for a reason. In order for the defendant to be allowed to use deadly force, that threat to her life must be imminent. It had to be ready to happen. It had to be staring her in the face, such as she had to act at that moment to protect her life. If Ms. Owens would somehow have managed to bust through this locked, deadbolted metal door, entered her house, and started coming at her, the defendant may have had a right to shoot, because that danger would have then been imminent. But that's not the situation we have here. We talked about Part A, imminent death or great bodily harm to herself. She would also have the right to use deadly force if she needed to do so to prevent the imminent commission of a burglary, murder, or aggravated battery against herself. Murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, there's no evidence to support that at the time the defendant fired that gun, that Ms. Owens was about to murder her. Ms. Owens had no ability whatsoever to even get into that house, to even try to cause her harm. There is the secure, locked, deadbolted metal door. It's not a situation where Ms. Owens was charging at the defendant with a gun, a bat, a knife, something like that, and she had to resort to use deadly force. That's not our situation. Similarly, the crime of aggravated battery is an intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement. Just like the previous explanation, Ms. Owens, at the time she was shot, had no ability whatsoever to even get into that house. It also is interesting to know that at no time during the interview does she claim to think that Ms. Owens had any kind of a weapon. There's no evidence to support that Ms. Owens was in the process of committing an aggravated battery or about to cause her imminent, immediate harm when she fired that gun. Talk about burglary. The defendant would be allowed to use deadly force to prevent the imminent commission of a burglary upon herself. Well, what is burglary? Burglary is entering a structure owned by or in the possession of another with the intent to commit a crime therein. And the crime can't be burglary or trespass. The judge also read you the definition of structure: kind, temporary or permanent, that has a roof over its head and the enclosed space of ground and outbuildings immediately surrounding the structure. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. Based on the law, there is no doubt the inside of the defendant's house is a structure. This is a situation where Ms. Owens is standing on the other side of the door, yelling at the defendant to come outside. There's no evidence whatsoever that Ms. Owens was trying to enter her residence. She's not jiggling the doorknob. She's not, shattering the sliding glass door or anything like that. There's no evidence that Ms. Owens said anything to indicate she was going to bust into her house. No evidence that Ms. Owens was committing a burglary of getting into her house or trying to get into her house. Also included, though, in the definition of structure includes the enclosed space of ground and outbuildings immediately surrounding that structure. That would include the defendant's porch area. The evidence has shown that Ms. Owens walked onto her porch area, the defendant's porch area, to bang on that door. So Ms. Owens did enter that portion of the structure, that porch area. But what's important about burglary is that second sentence up there in the first paragraph, or the first sentence, I'm sorry. In order for something to be a burglary, the person would have to enter the structure with the intent to commit a crime. That's why the mailman or the Amazon delivery guy can come onto the porch and drop off a package and not be charged with burglary because there's no intent to commit a crime. Also important is the crime that is intended to be committed cannot be burglary. Obviously, you can't use the charged crime with the intended crime be the same, and it also can't be trespass. The crime has to be something other than Ms. Owens walking onto that porch by the law that we all have agreed to live by. That crime that intended to be committed to be a burglary could be theft, could be vandalism, could be some violent crime towards a person, but it cannot be simply walking onto that porch. So if you're thinking, well, Ms. Owens walked onto the porch, therefore she intended to commit a trespass, therefore it's a burglary, therefore the defendant has the right to shoot, that would be legally incorrect. That would be a miscarriage of justice. It's legally insufficient for that to constitute a burglary. In order for the defendant to have the right to shoot Ms. Owens, there has to be it has to be done to prevent the imminent, immediate, about to happen commission of a burglary. And that burglary would have to be that Ms. Owens came on the property with the intent to commit some crime. Ms. Owens came onto the property to have the defendant come out to discuss this issue. It's not a crime to bang on somebody's door. It's not a crime to yell. There is no evidence that she came over there with any other intent but to get the defendant to come out and talk. That's why Ms. Owens' actions don't constitute a burglary. The judge also read to you an instruction that Susan Lorincz is presumed to have held a reasonable fear of imminent peril, of death or great bodily harm to herself when using defensive force that was intended or likely to cause death or great bodily harm if these two things happen. The person against whom the defensive force was used, in this case, Ms. Owens, she was the one that the force was used against, was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling. And the defendant knew or had reason to believe that the unlawful and forcible entry or the forcible act was occurring or had occurred. Notice what this instruction requires. The person was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered the residence. Not that the intruder may want to come in or could come in. The intruder has to be in the process of entering the residence or in the residence. We don't have that here. As we discussed, there's no evidence whatsoever that Ms. Owens was actually in the process of unlawfully or forcibly entering the house. The defendant is not entitled to any kind of presumption that she was in fear. Based on the law that we went over and the evidence and circumstances surrounding the defendant when she chose to fire that gun, which killed Ms. Owens, her actions were not reasonable, and she was not allowed to use deadly force legally based on the law. Now, you heard from a crime scene expert, Joshua Wright, who explained where he thought the defendant was standing when she fired the gun in the house. You heard from a computer graphics gentleman who did the video that we saw and some of the photogrammetry information that was yesterday. And those representations relied heavily on what the defendant said happened, her own version of events. You also heard from Roy Bedard, who talked in generalities about how people make decisions in stressful situations. Ladies and gentlemen, none of that testimony sheds any light on the reasonableness of the defendant's decision or the imminence of the threat that she perceived. Ladies and gentlemen, because the evidence has proven beyond any reasonable doubt that the defendant's decision to use deadly force by pulling that trigger, and because her intentional act of firing through that door caused the death of Ajike Owens, we're asking you to find the defendant guilty of manslaughter with a firearm. Thank you.
Ladies and gentlemen, we're going to take a short break, about 10 minutes, and then we'll come back and hear the defense closing argument. What we'll do, the jurors are outside the courtroom right now. Depending how long the defense goes, if they get like
So they cut the audio. Thanks. Did you guys catch how Ponytail came through trying to ask for another acquittal before closing arguments? It's like, sis, really? Like, that's not even reasonable. What made Ponytail think that they were going to go for an acquittal after spending a whole entire week and he already told you no? Judge, I'm just coming back with my original argument. He's like, no. So they're going to, so the prosecutors just gave their closing argument, which I think they did. They did a pretty good job. I'm not sure in Florida if they get a second chance. So you do your closing argument, then the defense does their closing argument, and then the prosecutor will have a chance to come back one more time. And then I think the defense gets another chance. It's almost like another little mini, like, okay, we didn't. I just hope, I do think that the prosecutor laid the groundwork for this was not a reasonable self-defense. Like this, she says it's self-defense, but it wasn't necessarily reasonable because she was behind a closed door. And the assumption that someone is coming over to do something to you. If that were the assumption, the actions behind what your assumption was, I mean, you were wrong. Like any way you look at it, based on what happened the minute Ajike stepped on her patio to the minute that Susan shot her gun, regardless of race or previous interactions, you don't shoot based on assumption. You are using deadly force based on what's actually happening. And what actually was happening wasn't justified to use deadly force. I think she was brought to the hospital, but maybe she was already deceased. She got a deadly wound. They started doing CPR and addressing the wounds. They saw you can see on the body cam that she was laid flat out. They saw the wound. There was no exit. They were trying to see, they were doing CPR, things like that. The bullet went in somewhere in her abdomen and it went somewhere by her ribs. But it penetrated a couple of vital organs. She probably was just bleeding inside. Based on what hit, she probably bled out from the inside. And so we'll go back and watch day one, because day one for the prosecution had a lot of information. We didn't stream that. I was watching some on day one, but I was getting prepared to kind of talk to you guys about what was going on. And we didn't watch, no, we didn't watch we missed most of day one. So yeah, we got into day 2, 3, and now this. So we'll get back to actually day one. The neighbor guy who lived in the unit that flanked the field testified. The 2 sons testified. One of the neighborhood kids testified. All of the things, the sheriff's department who came out, all of those things. So we really saw the tail end of the prosecution and we saw all of the defense. So they did bring it, they brought a bunch of really good witnesses. So I think, and I hate to put it this way because I don't want anyone to feel like if you're not a mom, you don't understand or you're not a parent. But anybody who is on that jury, who's a parent, who's had to stick up for their kid against an unreasonable adult or even a unreasonable situation, this is scary because sometimes you have to stand up for your kids and they may not always be right. They could even be wrong, but you want to stand up for your kid. Um, Even if it's just having a conversation with someone who understands the boundaries of right, I'd like for you to reach out to me. If there's an issue with my kid, they're misbehaving, any of those things, I need for you to reach out to me. I don't want you to address my children. Parenting is my responsibility, not yours. And please do not throw articles, items, things of that nature at a child. But I do think, just as she was calling the police on the parents, specifically AJ and others, um, they should have been calling on her. You don't get the right to mistreat kids because you want the pleasure or the privilege of a quiet neighborhood when you live in a neighborhood full of children who actually enjoy being outside and want to play outside with each other. Go figure. Okay. How many people would love to be in a neighborhood with a bunch of kids that get along, have fun, and play? Like, are you kidding me? That's a blessing. But Susan was so bothered by these children, maybe due to her experiences early on. I don't think that was introduced in the case, but when the sheriffs interviewed her, sis don't like kids, in my opinion. She doesn't like kids. And that's fine. People don't. And that's okay. I'm not even going to vilify her for that. Speak to the parents, right? And when the parent you said to come see you came to see you, you shot through a door. I don't know. We're going to see how it turns out. I think it's really, this will just be something in the back of my mind um, on addressing people regarding certain matters because people out here are very unreasonable. People out here want to be tough Tony, pick fights, and they're not willing to have a conversation. All they're willing to do is use guns and call police. So it's really, to me, like I said before in the chat, this is kind of an indictment against parents and moms that if you need to have a conversation with someone, and it's a problem, you could end up on the floor because somebody feels like they don't like how you're speaking to them and they feel there's a perception of threat. And it could be based on race. It could be based on language. She called me a bitch. It could be anything. And your people are planning a funeral. It's awful. So that's my opinion on that. I don't know how you guys feel. Um, anyway, um, I'm just gonna highlight on some of your, but yeah, they're still at break right now. I think the defense is trying to figure out what angle they're gonna use to again make it Ajika's fault for coming over there. And I just hope that the prosecutor really leans on their their sensibilities. Let me say it like that. And also drawing from their experience as being a child, whether you're precocious, whether you're, have, whatever you're doing, not saying that the kids were precocious at all, but um, at the end of the day, sometimes the kids aren't always right. But in this situation, it really doesn't matter because they're juveniles, they're young people, and that's what you have parents for. And the person who is legally able to speak for them, it just seems funny how Susan would have all these interactions with the children, but when the parents and the adults came around, she didn't have anything to say. Like, too much. And then also, as you heard, she did not want them in that field. And the field was not part of the property under the domain of the landlord or anything. She was bothered. It's like living across the street from a park and being mad that you live across the street from the park. Um, I don't know what her financial situation is, but it can't be good. And this is again opinion, but she was living in that quadruplex housing, which doesn't mean anything, but she had a job. She was gainfully employed. So I think at the time she was supporting herself. When I looked up her name, I did see that obviously the rental ended in dispossessory. So there was probably nobody to close out her rental. So she'll have a dispossessory on her credit. She could have potentially lost her possessions. We don't know. She was gainfully employed. She's now spent over a year in jail. If she is acquitted, um, she is out of the job market for well over a year. And I don't know how it's going to turn out for her. If she goes to jail, she could spend up to 30 years in jail. If she's acquitted, I think financially she's probably going to be lost. If she has relatives to help her, she'll have to spend some time getting back on her feet because I don't think she has anything. I that's just an assumption. But when they were asking her about family, she said she had a sister who was a brittle diabetic, and that was it. I don't know if she has nieces and nephews or cousins or anybody like that. She is 60 years old, if you can believe it. Because guys, 60 these days is like 40. You know what I mean? Like, we don't want to grow old, okay? And not to say old is a bad thing, but we're doing these years differently than 40 and 50 years ago. I mean, 60 is giving, traveling, enjoying life, getting rest, drinking water, doing all the things, looking amazing. Um, so they said she has health problems, and that could very well be the case, but baby, it's, I definitely hope that there is some jail time for this. However much she gets is however much she gets. I just think my assumption is that she's in some financial ruin because I don't think that she was doing it big. And I don't know if she could have some savings, some 401, girl, 401k. She could have something, but I don't know for indigent status. I don't know how you achieve that, if she would have had to liquidate any potential retirement, life insurance policies, things of that nature, if she even had that. Um, Now, if you watch the interview with the family, they are in position. I'm sure based on today's verdict, there will be a civil lawsuit filed against her. They're going to finish her one way or the other. She's either going to, if she gets a conviction, then maybe they're going to leave it at that. But based on what the family attorney stated, is that they have instructions based on the outcome of this trial, what their next move is. If she is acquitted, they're probably going to do some sort of civil action based on wrongful homicide or something, some sort of personal attachment, to get some satisfaction, and that her last of her working years will be spent in reimbursing and paying some sort of restitution, some sort of settlement to the children and the family of AJ Owens. That's just what I'm thinking based on what I've heard. Anyway, I'm gonna go back on silent and we'll listen to the rest of this. And when it's done, they'll probably be able to break before lunch. So I might do a Nesto break. I'm not sure. But we'll replay day one and then cut through all the breaks and stuff like that so we can get through like 7 hours, maybe in like 3 or 4 or something like that. Just get through and just see all of the testimony. Okay. I'm just going to say I don't like this lady. Miss Bust Down Blunt, 1B, Bob. I don't like ponytail, and homie looks like he had like several drinks last night. I'm sorry.
Welcome back, ladies and gentlemen. We will now hear from Ms. Sizemore.
May I please report,
Yes, ma'am.
counsel? Good morning. This case is about perception. The Constitution of our country embodies the right to be able to defend ourselves. And there's a wisdom in our laws that begins with this concept of perception. It's central to self-defense because the law protects that reasonable perception. The law demands that we assess the reasonableness of that perception, not from the comfort of a courtroom. But we have to take ourselves back to the perspective of the moment itself. The law requires each and every one of us to look at the circumstances that Susan Lorincz was facing on June 2nd of 2023. She was almost 59 years old. She was in her home where she lived alone, a troubled neighborhood to say the least. It was nighttime. She was suffering from a multitude of medical conditions when she was startled by a barrage of screaming of profanities and banging on her door so hard that the walls were shaking in a cement block house. Now, the judge has gone over with us some of the law in this case, and it's very, very important, particularly when we are dealing with self-defense. And I know Mr. Buxman went over a little bit. I need to go over it with you, and this is the only opportunity that I have to speak with you, so just bear with me. In jury selection, the judge talked to us about this plea of not guilty and reasonable doubt. He sort of went over that instruction, and he gave it again, and there's a reason that it's one of the first instructions that we get. It's sort of the foundation of our system of justice. So what does it tell us? It tells us that Susan Lorincz has entered a plea of not guilty. This means you must presume or believe that she is innocent. So we start there. We start with the fact that she's innocent, and where does it go? Where does that presumption go? It stays with the defendant as to each material allegation in the information through each state of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. That's pretty powerful language for the protection of our liberties. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. We talked about this term reasonable doubt in jury selection. I'm not going to read the whole definition to you again. The judge gave it to you again. And it's very important. And what is reasonable doubt? It means you have to be sure. Really sure. The law says you should only convict someone if you're convinced they're guilty beyond a reasonable doubt. You should feel confident in your decision without hesitation. So if there's something in the evidence that gives you pause, if you're back there and you're deliberating and you're thinking, man, she was an older woman. She had some medical issues. She did live alone. She had these prior run-ins with Ajike. I could see how she could be scared of her. and you're thinking, I did see the damage on that door. That's reasonable. I could see how she could be afraid that she was going to get through. If you're back there and you're pausing and you're hesitating, if you're wavering and vacillating, that's reasonable doubt. And if you have a reasonable doubt, you should find Ms. Lorincz not guilty, because that is what the law says. And each and every one of you took an oath to follow the law. So where do we look for reasonable doubt? It is to the evidence introduced in this trial, and to it alone. Only the evidence introduced in this trial and nothing else, that you are to look for that proof. It may arise from the evidence, the conflict in the evidence, or the lack of evidence. And if you have a reasonable doubt, you should find the defendant not guilty. Justifiable use or threatened use of deadly force. This is a very, very important jury instruction. You're going to get to work with this when you're deliberating. The laws in Florida give citizens the right to defend themselves when they are faced with imminent danger. Deadly force means force that is likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. And the most important thing in this part of the jury instruction is where it says, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So they not only have to prove to you that she committed this manslaughter, but they also have to prove to you beyond a reasonable doubt that she was not justified in using deadly force. Now, Mr. Buxman went over this, Judge Hodges read this to us, and there's a couple important parts of this jury instruction that we need to focus on. And one is, if Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat. If you remember during the trial, Mr. Smith had asked some of the witnesses, did Susan shoot from way back there by her bedroom? Did she shoot from behind that countertop or behind that kitchen? It doesn't matter, because she has no duty to retreat, and she can stand her ground when she is in her dwelling if she is faced with imminent danger. Another important part of this is if she reasonably believed. We do not judge Susan Lorincz with what we in this courtroom have experienced in life. It's not what I would do, or Mr. Buxman or Mr. Smith would do in that circumstance. It's what Susan Lorincz reasonably believed was necessary to prevent. That's a very important word, prevent. The law does not say that you have to wait to get punched or attacked before you can do something. That's not what it says. You can use deadly force to prevent someone from coming into your home and hurting you or attacking you. Because members of the jury, if someone who is on the outside of your door that is banging and pounding so hard wants to get in that house and they do, it is too late. There are way too many variables if someone actually gets inside. Your gun could jam. You could get rushed. You could fall, especially if you have medical conditions. So the law accounts for that. You can do what you need to do to prevent that from happening. What was Ms. Lorincz confronted with on that night when she had to make a split-second decision? We heard from Dr. Roy Bedard. He's a world-renowned use of force expert, trains law enforcement officers all over the country, and he talked to us about how someone reacts under stressful situations, these high-stakes decision-making. And he told us that when there's high consequences, you don't really know if the person on the other side of the door or the person that's confronting you is armed. Not just Susan Lorincz, but most people go to the fact that this person is armed, that they are a real threat. That's reasonable. And Susan Lorincz had no idea what Ajike Owens had on her. He told us that biologically, what happens in your brain and you're stressed, you have these high anxiety situations and it's releasing all of these things, your adrenal glands, and it's a high stress situation. And people have to make life or death split second decisions when they're going through these things. He told us how a person perceives time differently. That something that was a second may have actually been a minute. And he told us that if someone's older or if they have prior negative dealings with somebody, all of those things can affect their decision making. It's very difficult for someone to judge what is going to come next. And the law says that Susan Lorincz can defend herself to prevent the imminent commission of burglary, murder, or aggravated battery against herself. So this sort of lays out the definition of those things, and I'm not going to read it all again. But there's an important thing that I want to point out about the crime of aggravated battery. It's defined as intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to another. We heard from Dr. Norford, the medical examiner in this case. And on cross-examination, she told us, yeah, I mean, if somebody is hit or kicked or punched, and that person is older and they have medical conditions, that could cause great bodily harm to them. So if Ajike Owens gets through that door and just punches or kicks or hurts Susan Lorincz, that could cause her great bodily harm. We heard the statement that Susan Lorincz gave to law enforcement. We heard two of them. And Miss Lorincz told detectives on the night of that incident, Miss Owens was pounding on her front door so hard the walls were shaking. She told detectives that Miss Owens was screaming at the top of her lungs and that Susan told her, "You're trespassing, you need to leave." Susan Lorincz told detectives, "I really thought she was going to break my door down. I really thought that. I saw the door moving in, and I really believed that. I honest to God believe that." That is what she said. She reasonably believed that. We heard Susan tell the detectives, "I heard Miss Owens say, 'I'm going to fucking kill you.'" She heard that. Miss Lorincz told them, "I heard the door crack. And when I heard that door crack, I fired." We heard from Joshua Wright, the ballistics expert, and he sort of worked in conjunction with Toby Terpstra, and they created this 3D visualization that you saw. And what's important about Mr. Wright's testimony is that it's consistent with what Susan Lorincz told detectives. "I was standing back near the table. There's no evidence that she moved this shell casing or did anything like that." It's consistent with what she told them. Miss Lorincz told them, "I wasn't going anywhere near that door. I was terrified it was going to come down." And he told us, yeah, it's pretty likely that Susan was standing by her table when she fired the gun. So how do we decide whether somebody is justified in using deadly force? And this paragraph sort of guides us in that. And it tells us that you must consider the circumstances at the time the force was used, all of it. The fact that she's in her home, she's alone, it's nighttime, her knowledge of Ajike Owens and her past interactions with her, the noise level with the pounding and the screaming of the profanities, the the problems that Susan Lorincz was having physically, all of it. You have to take into account those circumstances. It's what she would reasonably do. The beauty of the law is that it does not punish individuals that reasonably perceive that danger. Now let's talk more about that danger, because the law goes one step further and it tells us that the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. And we know that it was real to her because we heard her in her statements to detectives. I really thought I heard that crack and she was coming through that door. She just believed that. And if she believes that and she perceives a danger and that danger is reasonable in her shoes, she can defend herself. She does not have to wait. So was it reasonable for Susan Lorincz to think that she was in a dangerous situation where she could be hurt or killed? This is what was standing between Susan Lorincz and Ajike Owens on June 2nd of 2023. Ajike Owens was a 35-year-old woman who was 5'7", weighed 293 pounds, and was very, very angry at Susan Lorincz. A door frame that was broken and barely hanging on. Now we heard from Charles Gabbard. He told us, I tried to fix this door as best as I could. I put some screws in it, put some putty in it, and it was structurally sound. He made a point to let everybody know it was structurally sound. Not really sure how he knows that. He didn't really do any testing, but he wants everybody to know this is not my fault. As a landlord, that door was structurally sound. But it doesn't really matter whether it was or it wasn't. What matters is that Susan Lorincz knew the shape of the door and what it was like on that day. And she believed that door wasn't going to hold up. And was it reasonable for her to think that? Absolutely. All we have to do is look at the photos. The crack goes all the way down the frame. Almost all the way down. Was it reasonable for Susan Lorincz to hear a crack when Ajike Owens was banging so hard on that door? Absolutely. Miss Owens was a woman who ignored not one, see the no trespassing sign on the window, not two, but 3 no trespassing signs. 3. And we know this was not the first time that Ajike Owens had trespassed on Susan Lorincz's property, and we'll get to that a little bit later on. Miss Owens was very, very angry. How do we know that? What evidence tells us that? We know that there was an interaction that Susan Lorincz had with Ajike's sons, Israel and Isaac. Susan talked a little bit about it in her statements to detectives. There was an issue with a tablet and a pair of skates and an umbrella. And Miss Owens went over to confront Susan Lorincz about it. And we heard from Yaro Rodriguez, and he took the stand and he told us, Miss Owens was mad. Yaro Rodriguez told us Miss Owens' tone was a loud and a mad one. He told us Miss Owens was screaming and using words like bitch and fuck. And he told us, at first he didn't admit it. He was like, I didn't see her knock on that sliding glass door first. But we reminded him, you gave us a deposition and you told us about these things. And he said, yes, actually, I did remember. I did see that. So she went straight to this sliding glass door and she started pounding as hard as she could. And we heard from Jareth Gardner. And he told us that he was over by the basketball hoops, and when Isaac and Israel came up to him and told him something that had happened at Susan's house, and he told us one of the kids said, "Go get AJ." He didn't really want to tell us, but he admitted, yeah, she seemed frustrated. Miss Owens seemed frustrated. And that he heard Miss Owens knocking and then knocked again, but this time it was louder. He told us that he heard Miss Owens say, "Bitch, open the door." And he told us that Miss Owens' demeanor was like somebody had just messed with her kids. And he told us that even he started walking over to Susan Lorinc's home because he felt the energy and he knew an altercation was about to happen. This was not a woman that was coming over to have a nice chat with Susan Lorincz about what had happened with her children. We cannot ignore the realities of what happened that night. The state may compare this to someone just coming on to the little, "Come on, Susan, I want to talk to you about what happened with my kids." That is just not what happened. Miss Owens was screaming so loudly that Rosalie Smith, a neighbor that lives a football field away, heard her. She said it was so loud. So if you can imagine how loud it was for Rosalie Smith, who was a football field away, imagine what that felt like for Susan Lorincz, who was right on the other side of that door with that broken door frame. Miss Smith told us it wasn't just 3 bangs and then another 3 bangs. She told us it was a lot of pounding. I mean, a lot. And that it felt like even to her, it went on forever. Yariel Rodriguez told us Miss Owens was banging on the door hard, and she was banging with her fist. I mean, he told us this is what I saw, and that she was banging in the middle of the door. And we heard from a really important witness, Yvonne Costa. The state called her as a witness, and that's Susan's neighbor that shares that wall with her. And she told us that all of a sudden she heard a banging that was really, really bad. I mean, so bad even her walls were shaking. So bad that she was scared. So it's not just Susan Lorincz saying, "Man, that banging was so loud, I was scared." Her neighbor says, "I was terrified." That's how hard it was. She told us that the banging stopped and then she heard it again, and then at this time it was even worse. And that there was a lot of it, a lot of banging, not just 1, 2, 3, 1, 2, 3, a lot. She told us that while she heard the banging, she heard voices, loud, aggressive, very guttural and deep voices, and that it sounded like it was coming from outside. Miss Owens was angry. And if she got through that door, and Susan Lorincz thought that she was going to because she saw it moving in and she heard that crack, she was in fear for her life. Ajike Owens was trespassing on Susan Lorinc's property. And Susan Lorincz was in her home where she had a right to be, and she had no duty to retreat. She had a right to stand her ground and defend herself because she was reasonably afraid. Now, the state may say, well, Susan Lorinc's fear, that wasn't reasonable because Ajike Owens never got through that door. She didn't go over to Susan Lorinc's house to harm her that night. She just merely wanted to go onto her porch and talk to her They may say, well, did she trespass? Maybe. She never intended to harm her. But the law on self-defense accounts for situations just like this. Situations where someone unlawfully and forcefully comes onto someone else's property. The law tells us, hey, there are certain circumstances where if certain things happen, you can presume that someone has a reasonable fear. If certain things happen, you can presume that the person was going over there to cause harm. And these next two slides, they deal with that portion of the law. And we sort of have to read these in conjunction with each other. And so I want to go over the definition of dwelling. And this is something that Mr. Buxman didn't talk about. And this is really important. So dwelling means a building or conveyance of any kind, including any attached porch. Whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. So remember that includes any attached porch. So when we go back and we're looking at this, the person against whom the defensive force was used, aka Miss Owens, was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling. So a dwelling includes an attached porch. So did Miss Owens unlawfully and forcefully step onto that porch? Absolutely. Not the door. We don't have to wait for her to get inside the actual house. The patio is part of the house. The law tells us that. So did she unlawfully go there? Absolutely, she was trespassing. Did she forcefully go onto the porch? Absolutely. How do we know that? Yariel Rodriguez, Jareth Gardner, Rosalie Smith, Yvonne Costa. She's yelling. She's angry. She's loud. She's banging. That's forcefully. That's what makes this different from someone like an Amazon driver coming to deliver a package. Miss Owens forcefully went on that attached porch, and that's the dwelling. And if that's the case, we have to presume that Susan Lorincz had a reasonable fear, because the law tells us that we have to. If that's the case, we have to presume that Miss Owens was going over there with the intent to commit an unlawful act. We have to presume that. We don't get to guess that. Well, maybe she wasn't going over there, she was just trespassing. No, the law says if she unlawfully and forcefully entered that attached porch, we have to presume she was going over there with the intent to do harm to Susan Lorincz. This slide is really important. If you find that Susan Lorincz, who because of prior threats or difficulties with Ajike Owens had reasonable grounds to believe that she was in danger or death or great bodily harm at the hands of Ajike Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. So let's talk about those prior incidents that we heard about. So Deputy Coleman testified. The state called him as a witness, and he told us, yeah, I went out there February of 2022. And he told us, Susan Lorincz told me that Ajike Owens had battered her with a trespassing sign, hit her in the leg. And Deputy Coleman spoke to Ajike Owens. And he told us that Miss Owens told him, my dog likes to defecate on Susan's property. That's his favorite spot, and I don't care. That's where he's going to go. And unless she can show me a deed or something other than that, that's where he's going to go. Deputy Coleman talked to Miss Owens about this interaction that she had with Susan Lorincz. And Miss Owens again told the deputy, yeah, I told her, I don't care about your sign. I can go get myself a sign if I want. I don't care about it. And she admitted to Deputy Coleman, yeah, I threw the sign. Deputy Coleman told Miss Owens, look, even though she's renting, that is not public space. That is private property. You cannot go over there. If you have an issue, call us. Coleman told us that he saw a red mark on Susan's leg, but despite that, he never arrested Ajike Owens. But we heard from London Remy, though, right? She was there and she saw this. She told us, I saw the sign hit Susan's leg. I mean, it barely hit her, but it hit her. For whatever reason, deputies decided not to arrest Ajike Owens. Deputy Coleman told us that Susan Lorincz had taken a photograph of Ajike Owens when they were having this confrontation. And this was entered into evidence, and it was stipulated to that this is the photo that Susan Lorincz took of Ajike Owens on February of 2022. Now, we also heard from Shelby Kinsey, and she was another deputy that had responded out in December of 2022 because of another altercation between Ajike Owens and Susan Lorincz. And Deputy Kinsey told us, I spoke to both Susan, I spoke to a mother, didn't even get her name, but spoke to a mother. We later learned it was Miss Owens, and Miss Owens told Deputy Kinsey, yeah, my 9-year-old son was mouthing off to Susan Lorincz. Miss Lorincz had told Deputy Kinsey that Miss Owens came to her house, knocked on her door, and said, if you treat my son like this again, I'm going to rip your ass out of your house and beat you up. Again, on that night, Miss Lorincz told Miss Owens, you are trespassing. Please leave my property. But Miss Owens didn't leave again on that night. She said, I have my son here, and I'm just going to talk to you about what happened. Susan Lorincz said, get off of my property. And when she felt threatened, she called the police, and that's when Ajike Owens left. Deputy Kinsey told us that Miss Owens herself said, Susan told me I was trespassing. Leave. I didn't leave. I wanted to talk to her about what happened with her and my son. Deputy Kinsey told us that Miss Owens herself told her, I said to Susan, if you walk up on my sons again, you're going to have to deal with me. Those were Miss Owens' own words. Once again, Miss Owens wasn't arrested, and Deputy Kinsey told her, you can't go over there. If you have an issue, call us. In her statement, Susan had told detectives about another time that Miss Owens had followed her a couple months before this incident, where she was like a foot behind her and she was following her almost all the way into her house. And that's the reason why Susan Lorincz had all these no trespassing signs up, members of the jury. She just didn't want people on her property. Now, this slide and this part of the jury instruction sort of deals with that same premise of if there's prior interactions between Miss Lorincz and Miss Owens. And this talks about, if you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Ajike Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. Now, Mr. Buxman said, well, threw the sign, hit Susan Lorincz in the leg. London Remy told us that it did, but who cares? It was a flimsy little sign, no big deal. Maybe it's not a big deal to him, But it could be a big deal to Susan Lorincz as she's experiencing a traumatic situation. And it's something you have to take into account. And she knew that she had been previously battered by this woman. It was a big deal to her, to Susan. And that's what matters. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Susan Lorincz and Ajike Owens. Why does the law do that? Because it recognizes that a 35-year-old, 293-pound woman is much more dangerous if she gets her hands on a 58-year-old woman with the physical problems that Susan Lorincz had on June 2nd of 2023. Ajike Owens has much more capabilities, and Ms. Lawrence's medical records are in evidence, and you can take your time when you're deliberating and you can go through them and look at all of those things. And we heard Susan talk about all of the medical conditions that she was suffering from when she spoke to detectives about her cervical fusion and her bad knees, and her knee going backward, and all of those things. The law says you have to take those things into consideration. I want to play this visualization for you one more time, but as you're watching it and as it transitions into the part where Susan Lorincz is in her home before she fires, I want you to focus on the door. Now, the state asked, I believe it was Mr. Smith, they asked Toby Terpstra, you took some liberties with making this video. That video was created based on Susan Lorinc's statement to detectives where she told them multiple times, I saw that door coming in. I saw that door moving. She says that multiple times throughout her statement. That is what she said. So you can imagine how she sees this door moving the way that it is, and she knows that the door frame is damaged. How scary that must have been for her. And she had a split second to make a decision whether or not to fire her weapon. The state asked some of the witnesses about Susan Lorinc's demeanor after the fact. Made it a pretty big deal about, she asked about her cats. They asked another witness, how did she seem? She's like, well, I mean, I don't know. Is it really that unreasonable for someone as a pet owner who has two cats to just say, hey, can you just close my door so that my cats don't run out? Because she asked that question, that must mean she wasn't in fear. And I want to address this. This is my only chance to speak with you, and Mr. Buxman may get up and speak, or he will get up and speak after me. So I want to address this just in case. In her interview, Susan Lorincz, they ask her questions about her researching Stand Your Ground on that second interview from June 6th of 2023. But if we go back and we remember, during that June 3rd of 2023 interview, the detective says to her, the law says It has to be imminent. And he's explaining to her sort of the law, and she's like, okay. Is it reasonable for someone to leave that interview and go and research? Like, man, I wonder what the law really says about this. Is that reasonable? Absolutely. The state argues that Ms. Lawrence knew that law enforcement was on the way, but we know it took law enforcement almost 15 minutes to get there. 8:54 is when she called 911. First officer didn't respond on scene until I believe it was 9:08. A lot can happen in 15 minutes, members of the jury, when you are in fear for your life. A lot. One of the last times the police came out, when Susan Lorincz told them that she had been battered, they didn't even ask Ajike Owens her name. The state says it's only 2.5 minutes. Only 2.5 minutes have went by. But Dr. Bedard, he talked to us about that perception and how that can feel like a very, very long time. And the state introduced some videos that Susan Lorincz had taken earlier in the day, and they had introduced this umbrella, and they introduced these skates. Even Mr. Buxman in his closing admitted, like, none of that even really matters. But they took the time, they introduced those things. Why do they do that? Do these skates, the umbrella, these videos, prove to you in any way that Susan Lorincz wasn't reasonably afraid? Because remember, they have the burden to prove she wasn't acting in self-defense. During the trial, Mr. Smith made it a point to ask some of the witnesses, particularly our expert, Joshua Wright, did you see there could have been gunshot residue on that door? All the stuff about the gunshot residue. Did their crime scene tech ever test the door for gunshot residue? Did you ever hear any of that? It took law enforcement over 2 weeks to even go out and collect that door and place it into evidence. And by that time, Charles Gabbard had already got his hands on it, sanded it down, filled it in, painted it over, before they even collected the door and placed it into evidence. A door that they made it a point to ask the witnesses, was there any dents, any scratches on it? Waited 2 weeks after Charles Gabbard had done work to it to even collect it. So I want to talk to you just a little bit, and I'm almost finished, about the state's burden. And I want to show you a little bit about sort of how that means, or what that means. If you are anywhere along this chart, other than the red part at the bottom, you have to find Susan Lorincz not guilty. If you think it was self-defense beyond a reasonable doubt, she's not guilty. If you think, man, this might be self-defense, that's not guilty. Even if you think it probably wasn't self-defense, that's not enough. She's not guilty. It's not until you get down here where they've proven to you beyond a reasonable doubt that it was not self-defense. That is the only way that you can find her guilty, because the law says so. Now, this is the verdict form, and this is what you're going to see when you go back there to deliberate. And based on all of the facts and evidence, when you get back there and you're deliberating, we're going to ask you to check that box B. The defendant is not guilty. Thank you.
Mr. Buxton, can you, Ms. Sizemore, approach real quick? A very short break, then Mr. Buxman will have his concluding statements to you. Then we'll go from there, okay? very short break, and then we'll have some concluding arguments by Mr. Buxman. Then I will give the jury the rest of the jury instructions, probably 10 minutes or less on that. Then they'll deliberate. Okay. I do want to express my thanks to all of you for how you've acted during this trial. It's been wonderful. Everyone has acted completely appropriately, and I really appreciate that. But I want to let you know something that I used to tell people all the time is that everyone wants their side of the case to win. Everyone does that in a trial. But only one side can win a trial. And that's just the nature of things. Please, whatever the verdict is, whenever it comes back, remember that this is a courtroom. Everyone just remain silent. Ms. Lawrence, you'll remain silent. Everyone in the audience will remain silent. We'll have a few more things to do with the jurors, and then they'll be excused. Then, as far as you're in this courtroom, everyone don't say a word. Please don't express any, depending on whatever side of this you're on, no joy, no anger, no clapping, no nothing, okay? This is a courtroom. You're free to do whatever you guys want outside the courtroom. But in the courtroom, you're not free to do whatever you want. Everyone's got to keep the same perfect behavior we've had already. Again, I really appreciate that. I know that you can keep it up for the very short time we have left. We'll take about 10 minutes, and then we will finish everything up. And the jurors will do their deliberations, okay? Thank you very much.
Hey guys, I think we'll take a break while the jury is out. I mean, they could come back. It's Friday. They might be ready. They may have already made up their mind. I don't know. I'm going to leave the feed running for a bit. You guys are welcome to chat in here. I think by noon I'm going to go ahead and cut it, or maybe like in the next 30 minutes. I don't think they're going to come back that fast, but we might cut it, do something else for a minute. I might take a Nesto break or something, and then come back whenever the verdict comes. We don't know if we'll get it today. It could be Monday. You never know. So I'll leave it running for a bit so you guys can talk. But maybe by like 11:30, 11:45, I'll go ahead and cut the feed, and then we'll come back as soon as they get started. Okay. I'll be monitoring it. And when it gets started, we will resume. Okay. Oh, they're taking a break. Okay, the prosecutor's coming back. Okay, so that's the plan for when the prosecutor comes back. I'm gonna leave the feed. You guys talk, and then when they come back and close it down. So they're just taking a little break. Okay, my bad. Okay, my bad.
cold here today. You doing a second one or you doing both? Okay. You guys don't remember the day when the state sometimes was in the middle?
I do.
And then the fence got that.
I know.
Like when you were in county court, you didn't know what was going to happen until you had to like plan both ways. So, which really just meant splitting your one closing in two and doing it that way. But let's go back on the record. I see Miss Lawrence is back in the courtroom. And are we ready for the jurors, everybody?
Yes.
Okay. When I finish reading, I will, as I usually do, ask, is there any objection to the instructions as read?
And Judge, there was a couple words that you messed up.
Okay.
So I don't really necessarily want to say that in front of the jury, so you want to just wait until they're taken out?
Tell me now. I'll reread it.
I don't really think that it's necessary. I just didn't know that. Yeah.
Which word? I mean, if you have an objection, I need to address it now, and I'll re-instruct.
I have no objection.
But if you want me to is it like something?
I think you just said when there was, indoor injury, you said harm, and then you're talking about the capacity, then you said something different. But it doesn't matter.
Capabilities as opposed to capacities?
Yeah.
That's highly possible. Where is that in justifiable abuse of deadly harm?
It's at the end, for the capacities one?
For which one?
Are you asking about the capacities one?
Yeah.
Yeah, it's a justifiable use of deadly force under, when you're talking about the physical capabilities between the two.
So I said capability as opposed to capacity.
Yes, I believe so.
I can reread that if you would like me to.
You can reread it, but I don't have an objection.
I mean, they have almost the same definition.
Right.
Seems like capability is more appropriate anyways, but I don't know what capacity means. But if I said capabilities, if you want me, and I may have, okay, I have no question. If you want me to reread that, I'm happy to reread it. If you don't want to reread it, let me know.
I don't think you need to reread it.
Okay, so you do not want me to reread it?
Correct.
Okay, so the two words are basically interchangeable, more or less. So if anyone wants me to reread it, I apologize for misreading a word. If anyone wants me to reread it, tell me now. If not, then I'll consider it waived. All right, so I'll consider it waived. And we'll bring it back and I'll try to make sure I enunciate each word more clearly. The jurors have returned. Mr. Buxman, you ready to proceed? You need the screen? You ready for it now?
Yes. Thank you. I want to start by talking about a few things in the defendant's interview and the testimony of William Guard. And then I want to talk a little bit about reasonableness and eminence. You heard in the defendant's interview, I think on one occasion, there may have been two occasions, in which she indicated that Miss Owens damaged her door in the past? Well, look at the evidence that we have before us. We know the first incident that happened in February of 22, Deputy Coleman came. There was no indication that the defendant reported any damage to her door, showed Deputy Coleman any damage to her door then. We heard about the incident from February of 2023, February, and Deputy Kinsey responded. There was no indication of any damage done to her door. During the interview, the defendant talked about that third incident where she went over across the street into the driveway and confronted Miss Owens about telling a neighbor that she was a crazy bitch. There was no explanation or no discussion about damage to her door at that point. You heard from Dr. Roy Bedard, and ask yourself, what did he add to this case? He's not a psychologist. He's not a psychiatrist. He is not a medical doctor. He spoke in generalities. He told you about various theories. He told you about the structure in the brain and the adrenal glands and how people make decisions and what happens in a stressful situation. His testimony boils down to the more imminent and severe a threat is to someone, and the less time a person has to assess the situation and process the data, the more error that creeps into the decision. I talked with him about the example, if I'm driving down the road, the person ahead of me slams on the brakes. I have to make a split-second decision. Do I slam the brakes? Do I swerve right? Do I swerve left? Or do I just brace? If I have a half second to react to that, the chances of me stopping or avoiding the threat is lower. If I have more time to evaluate and process the situation and assess my surroundings, the chance of me making a reasonable decision and a safe decision goes up. That's common sense. The threat, this perceived threat that the defendant indicated she had that day was not imminent. The threat, assuming you can even call somebody banging on a door and yelling a threat, was a threat that was coming from the opposite side of a closed, locked, deadbolted metal door. It was not immediate. It was not imminent. It was not about to happen. There was no threat. And the defendant didn't have a split second to make a decision. She had a period of time to make a decision. And she made a variety of decisions during that period of time. And that's kind of what I want to go over in this part of my closing. She told the detectives that she thought the door was going to break in. She thought Miss Owens was going to burst through the door and kill her. We know that the defendant is prone to unreasonable degrees of fear. When she was talking in her interview about the sign throwing incident, she told the detectives, and then when the first time when she threw the things at me, she was just so horrible to me. I was like, I just had neck surgery. And I'm like, she could have really killed me. And I was just like, oh, dear God, she was just violent. She is describing an incident where Miss Owens picked up a no trespassing sign, about 8 by 10, with 2 little prongs that go into the ground, and tossed it at her as she was walking away. Is that reasonable to believe that that act could have reasonably killed the defendant? Of course not. And again, London Remy showed you how it happened, showed you that she tossed it. But she tells the detectives that she's like, Miss Owens could have really killed me. That tells you the reasonableness of her fear. And remember, we're looking at reasonableness through the eyes of an average, ordinary, everyday person. You heard about it, and we talked about the incident, the second incident that Deputy Kinsey responded to. And Deputy Kinsey told you that she walked up and talked to the defendant. The defendant's first complaint was about the kids trespassing. And only after that does she explain or say that, oh, Miss Owens said that she was going to drag me out and whip my butt. It's interesting that she never mentions anything about that on the 911 call. She doesn't say, oh my God, I had to shoot through this door. This woman had threatened me in the past. She doesn't say that. She doesn't mention anything about that statement in either of her 2 interviews, despite talking to the detectives for hours. Ask yourself, how much of a role did that event play in the defendant's decision-making process to fire the gun through that locked, deadbolted metal door? Let's look more closely at the circumstances about what was going on that night and look at her own words to assess how truly afraid and how reasonable her fear was. Her first 911 call.
Yeah, the subject is out there right now. I'm sitting for my head. I'm very scared.
It's a cell phone video from her phone taken 5 minutes before she makes the 911 call. That's what's causing her fear. That's taken moments before she calls 911. Ask yourself, is that a reasonable fear? That she's in fear for her life? That's not reasonable. So she tells the 911 operator that she is so afraid of these children. She's in fear for her life from these children. Does she run into her house, barricade her house that very moment? No. About 30 or 40 seconds before she calls 911, she's outside taking more video. But she just tells the 911 operator she was in fear of the children. Ask yourself again, is that reasonable? Her actions are completely inconsistent with somebody being in fear for her life from those children. Still the initial 911 call.
They just badgering me and badgering me. I'm just sick of these papers.
Does that sound like fear of the children, or does that sound like anger?
Are you or anyone else in danger right now?
I locked my doors.
She tells the 911 operator she locks her doors, so there is no danger. Those doors were still locked. That door was still locked and deadbolted when Miss Owens comes over. Now she says she was in such fear of these children, in fear for her life, based on what she told the 911 operator. But there's a chain up there on the door as well. Does she activate that chain? She does not. She doesn't add that 3rd level of security. Why not add that level of security if she was truly in fear for her life from these children? She doesn't do that because she wasn't afraid. She was angry. If she's in such fear of this 9-year-old child, does she take the chair that she says that she places under the doorknob and put it there for added security? No. Because again, she's not in fear of these children. She's angry. She had to walk right by that chair to go to the bathroom, like she said that she was when the pounding and things started. So we know from her interview that when this pounding and yelling began, she was in the bathroom. She hears this pounding and yelling, and she is so afraid, she goes and washes her hands. She tells you that the pounding and yelling stopped. Like it would stop if somebody is banging on the door, come out, and there's a pause for the person inside to come to the door or to react or acknowledge. Then when there is no reaction or no answer to the door, the pounding starts up again and gets louder. That is the complete opposite of somebody who is trying to get into the house. Again, there is no evidence that Ms. Owens was trying to get into the defendant's house. If she wanted to, she had every ability to do so. But she's banging, come out, pause and wait, bang again. And then the gunshot happens. If she wanted to get into the house, why not shatter the sliding glass door? Why not continually bang? Why not throw the body up against the door? None of that happened. We heard from Uriel Rodriguez, who said none of that happened. She was banging. And she was banging hard. State never tried to hide that, and I never tried to suggest otherwise. She was banging hard. As we talked earlier in my first closing, that the defendant she's not required legally to retreat because she is in her own home. So in order for her to claim and argue self-defense, she doesn't first have to retreat. But her actions inside the house are relevant to consider the degree of fear, the reasonableness of her actions, and the imminence of this perceived threat. So what do we know? When the banging and yelling starts, she's in the bathroom. This is based on her own words in her interviews. She doesn't shut and lock her bathroom door to put up another barrier between herself and this perceived threat. Instead, she leaves the confines of that additional safe space and walks towards the kitchen, towards the door. Does that sound like someone who is afraid for her life? Of course she's not, because there's a big metal locked deadbolt the door standing between her and the knocker and the yeller. In her interview, she admitted that the first words out of Ms. Owens' mouth were, "Why do you speak to my children this way?" Not, "I'm going to kill you. I'm going to come into your house." Why do you speak to the children this way? When the yelling starts, she doesn't go find her phone that she had 2 minutes earlier when she just hung up the phone with 911 to call again. Instead, she goes to the bathroom to wash her hands. Ask yourself, how truly, reasonably terrified is she? The banging starts up again and she goes to her bedroom. She grabs the gun from her bedroom, and she doesn't grab the .22, the Ruger, the little plinker that she called it. She grabs the more powerful .380 Remington firearm. She doesn't shut and lock her bedroom door where she is with the gun to put up another barrier between her and this perceived threat in case by some chance, if she truly believes that Ms. Owens is going to come into her house, now she has another barrier to protect her. She doesn't do that. She doesn't walk around the corner and point the gun ready and waiting. No, she doesn't do that. Instead, she leaves the additional safety and security and that additional barrier that she could have put up and walks towards the door. Walks towards this perceived life-threatening threat. She says she walks up to the kitchen table. She raises her firearm, points it at center of mass, where a person would be, and pulls the trigger. One shot, not a panic flurry of gunfire, one controlled, precise shot, a kill shot. Ms. Sizemore told you that the defendant, there's evidence that at the time, right before she shot, the defendant said that she heard a crack in the door. You will listen to both interviews and the 911 call. You look at the transcript. If you want to listen to them again, you have every right as a jury to listen to those interviews again. Nowhere in those interviews does she say anything such as, "I heard the door breaking, I heard the door cracking before I fired." If you want to listen to them again, you have every right to do so. There is no wood splinters on the floor. There's no new damage to the door frame. There's no wood hanging off when the deputies get there and the crime scene investigators examine it. There's no evidence whatsoever to indicate that there was a crack before the gunshot took place. You heard from Josh Wright and Toby Terpstra. They collectively created the diagram as well as the digital animation. And using the diagram created by the defense, before we do that, Catherine Medina, there was discussion about Catherine Medina doing the trajectory analysis and how that she didn't calibrate certain things. Her role was not to do a full-blown trajectory analysis. She's told you she doesn't have the training and the experience to do that. Her goal was to create a general representation of the trajectory. And even Josh Wright said, based on what she did, it may be a little larger cone of error, but her job and what she did and her representation was a good representation of where the defendant would have been in the path of the travel of the trajectory of the bullet. But take the diagram provided by the defense as true. Who fires a gun like this? She's trained. She's gone to the range. She's practiced. I think in her interview, she said she's watched videos of how to properly shoot and things like that. She even demonstrated in her interview that she held the gun like normal people hold the gun. People don't hold the gun over your head like that. That's the representation provided by the defense. That is inaccurate. That's not reasonable. People don't do that. In order for the gun to be brought down lower, she has to advance closer and closer to the door to maintain that trajectory line. Now, ultimately, does it really make much of a difference where the defendant is standing in her house when she fires? Not really. Does it matter if she's standing right by the kitchen table or if she's standing a foot or two up or a foot or two back? Not really. It doesn't change the facts in this case. What's important about where she's standing is, assuming she's even standing where she says she was standing, what's important is after she gets the gun, she's approaching the door. She's walking towards whatever this life-threatening threat that she thinks there is. She's approaching that threat. That is inconsistent with somebody who is afraid for their life. That's, unless you're a law enforcement officer or military or firefighter, most people don't approach the threat. They don't run towards the threat. You heard and saw the video reenactment created by Mr. Terpstra. He admitted that that was based on the defendant's version of events. The video and the way he went about creating it, it was pretty cool. It was neat. But ask yourself, what does it add to this case? It shows Miss Owens banging on the sliding glass door. Well, we know that happened. Gary Rodriguez told you that. It shows the defendant, or Miss Owens banging on the outside of the defendant's door. Well, we know that happened too. It showed the defendant walking towards the door with her gun raised and firing a shot through the door. We know that happened. And it showed the shooting of the projectile, the bullet, through that closed door and hitting Miss Owens. We know that happened. Now, he took some artistic liberties by making the mirror shake and the door shake, and he did that on his own. He's basing it on the defendant's interview, but he decided how to make that happen and how to artistically represent that, to represent the degree of force that the defendant said she saw. That's not evidence. That's a representation of his artistic representation of what he thinks the defendant meant and what the defendant said she saw. Again, the video was cool, but it really doesn't add anything to this case. So after the shooting, we hear she makes a second 911 call. And we heard during the first couple minutes of that second 911 call, she's crying. She's upset. Of course she's crying and upset, ladies and gentlemen. She just fired a shot. She knows she shot somebody and realized the gravity and the implications of what her decision was. But notice how her demeanor changes very quickly during that 911 call when she starts talking about the children.
Something keeps trespassing over here. They're bothering me and bothering me. They won't fucking stop. Her boys were here earlier. They keep leaving their garbage all around the house. Okay. And then I told them to take the crap away. Get the fuck out of here.
That's after she fires and after the first initial minute or two of her crying. She's still angry on the 911 call. You saw Deputy Barbosa's body-worn camera when they first made contact with the defendant. That happened right after she hung up with 911. She wasn't hysterical. She wasn't bawling her eyes out. She was calm. She was cool. She was collected. I think she asked to go in and get water and asked for something to be done with the cats. And look at her demeanor within minutes of being placed in the patrol car. She's, again, not crying. She's not hysterical. This goes to the reasonableness of her fear. Deputy Welfenberg described her demeanor as indifferent. As I said earlier, ladies and gentlemen, the law requires the threat of death or great bodily harm to be imminent before deadly force is used. There was no imminence at the time she fired that gun. The word imminent is very important. It's included in the law in the instructions for a very important reason. In order for the defendant to lawfully use deadly force, the threat to her life had to be imminent, had to be ready to happen, had to be staring her in the face such that she had to act at that moment to protect herself. Now, some of the defendant's medical records were introduced, and there's no dispute that she has those medical records and she has some medical conditions. And if this was a situation where Miss Owens broke down the door or broke that sliding glass door and was coming at the defendant, those medical records might be relevant because her physical ability to actually engage in a fight could be relevant to this case. None of that happened. Why? Because there's a big door standing between the two of them that couldn't be breached. The defendant knows what imminent means. You heard in in one of the interviews that she did, she gave an example to the detectives. She said, imminent danger is like when a 4-ton truck is coming straight at you and they are swerving with you as you try to run away. That's a very different situation than somebody banging on the outside of a secure door and yelling with no ability to enter. Ms. Owens is not a 4-ton truck. She was not coming at the defendant when the defendant fired. She was not swerving to try to get to the defendant as the defendant ran away. Ladies and gentlemen, the defendant didn't have a half second to process this. She had minutes to process this. All the decision making that we just went through in the beginning of this part of my closing, all the decisions she made, where she went, wash your hands, go here, walk around here, go to the trash can, grab a more powerful weapon, come and approach the threat and fire. And then she had the presence of mind to go back with the gun she just used to shoot and put it back in the trash can underneath the smaller 22 Ruger. Ladies and gentlemen, as a society, we do not condone shooting another person because of an act that may occur in the future, or because X, Y, and Z may happen, and I may be forced to defend myself. Law enforcement officers are not allowed to go around shooting people because the person may have a gun, may pull it out, may threaten the officer with it.
That's sustained.
The danger has to be imminent. Not, it could happen. It may happen. If 2 or 3 or 4 things occur, it may happen. That's not imminent. The defendant does not get to shoot Ms. Owens because Ms. Owens may somehow manage to get through that door and may then decide to attack. Because before that door is actually broken in, Ms. Owens has no physical ability to cause any harm whatsoever. That is the law that we've agreed to live by. Because there was no imminent danger when the defendant pulled the trigger, her decision to shoot and kill Ms. Owens was not reasonable and it was unlawful. We talked in jury selection that your role in this case is to determine whether or not the defendant's actions on the night of June 2nd, 2023 violated the law. It is not anyone's role here to determine if the defendant is a good or a bad person. And this decision that you're about to make should not be based on sympathy to Ms. Owens, her family, sympathy to the defendant. Your decision in this case should be based on the law as the judge reads it to you and how the facts that you know that have been proven apply to that law. And as I said when I started this, the facts really aren't in dispute. Ms. Owens is banging on the door yelling. She's angry. She's angry about how the defendant treated her children. Ms. Owens is not trying to jiggle the doorknob or break down the sliding glass door, break the window, not trying to get into the house in any way. Law enforcement was on their way. She gets her gun. She fires one shot, center of mass, which kills Ms. Owens. The judge will tell you that it's your duty to determine if the defendant is guilty of manslaughter. If you find the defendant guilty, it is his job to determine what the proper punishment or sentence should be, not yours. I submit to you that if you are back in the deliberation room talking about the case and you're thinking, what's going to happen if she is found guilty? You've already made your decision that she is guilty because that's what the evidence has proven. After you boil down the facts and circumstances, you really have to answer one question. Like I said when I started, following the laws that we have agreed upon, is it okay to shoot through that closed, locked, deadbolted metal door as someone who is banging on it and yelling, but posing no imminent threat? Based on the facts of this case, it's not okay. Based on the law in this case, it's not okay. Just being afraid is not enough. Just her saying she's afraid is not enough. Using that ordinary, average, everyday person standard, you have to ask yourself, were her actions reasonable? Was her decision reasonable? And was that threat imminent? Was it about to happen right now? Ladies and gentlemen, the facts of this case have proven her decision was not reasonable. The decision wasn't made while acting in necessary self-defense. It was not justified. Because of that decision, because of that unlawful decision, Ajike Owens lost her life. We ask you find the defendant guilty of manslaughter with a firearm, because that's what the evidence has proven beyond any reasonable doubt, and that's what the law requires. Thank you.
Ladies and gentlemen, if you listen carefully, have your final instructions, okay? Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You have heard testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. 2. The case must be decided only upon the evidence that you have heard from the testimony of the witnesses and has seen in the form of the exhibits and evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. Here, there is only one crime, so only one verdict may be returned. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It reads as follows. It says right on it, verdict. Count 1, the only count. We, the jury, find as follows as to count 1 of the charge. In parentheses, check only 1 as to this court count. The first choice, A, the defendant is guilty of manslaughter. If you check A, you must then answer the following question. Did the state prove beyond a reasonable doubt that, during the commission of the offense, the defendant personally used a firearm? You'll check either yes or no. The other choice, B, the defendant is not guilty. So say we all, dated, this is the 16th day of August, 2024. This will need to be signed in pen by the foreperson, and the bailiff will have a pen back there for the foreperson to use. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. This includes any sort of like Apple Watch or anything else where you can get and send emails or make phone calls. Okay, you'll need to leave that with the bailiff. If you have an old-fashioned watch like me, you're fine. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. A, these exhibits will be sent to the jury room with you when you begin to deliberate. B, if you wish to see any audio or video exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you don't like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Give me 1 second. Put my stuff together here. At this point, in just a few moments, you're going to go back to the jury room, okay? We'll have your lunch for you shortly. You can either eat lunch and then deliberate or deliberate through lunch. Choice is yours, okay? The evidence, the physical pieces of evidence that you can physically see and touch and look at, they'll be brought into the jury room for you. Electronic evidence, 911 calls, the recordings of the conversations and the statements, anything that you saw digitally on the screens, you'll need to request to come back out here to watch that, because obviously we have no computers in there for you to watch it. But send me a note, and then we'll bring you out here all together, and we'll all watch it. You can watch it as many times as you want. You can get as close to the screens as you want. The choice is yours, okay? There's no limit on your deliberations. You can take as long or as short as you need to decide this case. The final instructions that I just read, these instructions are for the foreperson. I have put the verdict form on the back of the instructions so it's easy to find. The other 5 copies are for the other 5 jurors. They don't have a verdict form, okay? The reason I said 5 is because 2 of you have been serving as alternates, and the alternates will not go back into deliberation. What's going to happen is you'll still get your lunch, but we'll have you take that in another room, and then I'll discharge you after that, okay? The alternate jurors are, and remember your numbers, juror number 7 and juror number 8. If you're our juror number 7 or number 8, I'm going to ask you, do you have anything left in the jury room? If so, please retrieve it at this time and bring it out here. The rest of you are not alternates. So as soon as they come out, I'll let you go back, okay? And give the bailiffs a few minutes. They'll bring in all the evidence for you. And they'll also bring in the instructions for you. Yeah. If you all would just wait there, the rest of the jurors, you'll go back to deliberate, okay? And we have the instruction for you. what I'm going to do is we'll have your lunch for you in the other room. And then when you're done with your lunch, we'll take care of you being discharged, okay? I'm going to ask you, even though you go home, not to look up anything about this case or discuss anything about this case until the end of the night, okay? Or if you hear the case is over. The reason for that is if something happens to one of these jurors, you could be brought back in to participate in deliberations. So I need to keep you as pristine as you are now, okay? So we'll take jurors number 7, number 8 to the other jury room, give them a lunch, and then you'll be discharged with my thanks. And I do appreciate it. Have a very pleasant day. The jurors have retired from the courtroom. Is there any objection to the instructions that I read?
No.
Did I mess up any words?
No, sir.
There was one error in there about the other trust. It's always one, but we're down to maybe one, so that's maybe progress. All right, so we'll be in recess until we hear something. Thank you all. Y'all want to look at the evidence going back?
Hey guys, okay. That was crazy. Child, they need to eat and deliberate. They do. I wonder if they come back after lunch. I'll keep the feed up for a little bit, and but I think they're going to come back. They probably at least would take an hour, right? So let's see. They could come back during lunchtime. You never know. So maybe I'll keep the feed up for a little while, but I might shut it down and then come back when they come back. So, because sometimes they need a certain number. Okay. It's 12:09 now East Coast time. So, yes, so do I. I feel like the prosecutor brought it back a little bit into perspective, hopefully, keeping our fingers crossed, that they get, the jury to really follow the letter of the law, not the perceived spirit of the law, right? Okay, guys, I'll be back in a little bit, and then we might cut this off and then come back. But the judge is still talking, but they've cut the feed as far as the audio. Guys, the sound is cut, just so you know. Hey guys. Okay, I'm gonna run back. I just want to run back this last little bit again. I wonder if they're going to take up their whole lunch. I wonder if they're going to come back from lunch and have a verdict.
Yes, sir.
You ready for it now?
Yes, sir. Thank you. I want to start by talking about a few things in the defendant's interview and the testimony of Roy Bedard. And then I want to talk a little bit about reasonableness and eminence. You heard in the defendant's interview, I think on one occasion, there may have been two occasions, in which she indicated that Miss Owens damaged her door in the past. Well, look at the evidence that we have before us. We know the first incident that happened in February of 22, Deputy Coleman came. There was no indication that the defendant reported any damage to her door, showed Deputy Coleman any damage to her door then. We heard about the incident from February of 2023, February, and Deputy Kinsey responded. There was no indication of any damage done to her door. During the interview, the defendant talked about that third incident where she went over across the street into the driveway and confronted Miss Owens about telling a neighbor that she was a crazy bitch. There was no explanation or no discussion about damage to her door at that point. You heard from Dr. Roy Bedard, and ask yourself, what did he add to this case? He's not a psychologist. He's not a psychiatrist. He is not a medical doctor. He spoke in generalities. He told you about various theories. He told you about the structure in the brain and the adrenal glands and how people make decisions and what happens in a stressful situation. His testimony boils down to the more imminent and severe a threat is to someone, and the less time a person has to assess the situation and process the data, the more error that creeps into the decision. I talked with him about the example, if I'm driving down the road, the person ahead of me slams on brakes, I have to make a split-second decision. Do I slam the brakes? Do I swerve right? Do I swerve left? Do I just brace? If I have a half second to react to that, the chances of me stopping or avoiding the threat is lower. If I have more time to evaluate and process the situation and assess my surroundings, the chance of me making a reasonable decision and a safe decision goes up. That's common sense. The threat, this perceived threat that the defendant indicated she had that day was not imminent. The threat, assuming you can even call somebody banging on a door and yelling a threat, was a threat that was coming from the opposite side of a closed, locked, deadbolted metal door. It was not immediate. It was not imminent. It was not about to happen. There was no threat. And the defendant didn't have a split second to make a decision. She had a period of time to make a decision. And she made a variety of decisions during that period of time. And that's kind of what I want to go over in this part of my closing. She told the detectives that she thought the door was going.
Patty, what do you want me to repeat? I'm just doing a repeat of this last little section because I'm gonna be honest, I was on the phone for about 25 minutes, this last little part, so I got lost. I can repeat the day. We can go back and repeat the day. I don't know if there's going to be a verdict. So today or after lunch, I mean, it's possible. Sometimes they say fast returns are guilties potentially. I don't know if this will be a fast return, not guilty. I'm not sure. Missed what you said, friend. I missed what you said. Will you repeat it? I didn't really say much. I just said I was going to just repeat this part. And if after this they're not back, because I've got it up on my phone to see when they come back. If they come back anytime soon, we'll break back to the actual verdict. But I feel like they're going to be out for at least an hour, right? Because the court secretary, everybody has to have their lunch, so they might just be giving them an hour anyway, and see if they might be ready.
Going to break in. She thought Miss Owens was going to burst through the door and kill her. We know that the defendant is prone to unreasonable degrees of fear. When she was talking in her interview about the sign throwing incident, she told the detectives. And then when the first time when she threw the things at me, she was just so horrible to me. I was like, I just had neck surgery. And I'm like, she could have really killed me. And I was just like, oh, dear God, she was just violent. She was describing an incident where Miss Owens picked up a no trespassing sign, 8 by 10, with 2 little prongs to go into the ground, and tossed it at her as she was walking away. Is that reasonable to believe that that act could have reasonably killed the defendant? Of course not. And again, London Remy showed you how it happened, showed you that she tossed it. But she tells the detectives that she's like, Miss Owens could have really killed me. That tells you the reasonableness of her fear. And remember, we're looking at reasonableness through the eyes of an average, ordinary, everyday person. You heard about it, and we talked about the incident, the second incident that Deputy Kinsey responded to. And Deputy Kinsey told you that she walked up and talked to the defendant. The defendant's first complaint was about the kids trespassing. And only after that does she explain or say that, oh, Miss Owens said that she was going to drag me out and whip my butt. It's interesting that she never mentions anything about that on the 911 call. She doesn't say, oh my God, I had to shoot through this door. This woman had threatened me in the past. She doesn't say that. She doesn't mention anything about that statement in either of her 2 interviews, despite talking to the detectives for hours. Ask yourself, how much of a role did that event play in the defendant's decision-making process to fire the gun through that locked, bolted metal door? Let's look more closely at the circumstances about what was going on that night and look at her own words to assess how truly afraid and how reasonable her fear was. Her first 911 call.
I'm sitting for my head. I'm very scared.
It's a cell phone video from her phone taken 5 minutes before she makes a 911 call. That's what's causing her fear. That's taken moments before she calls 911. Ask yourself, is that a reasonable fear? That she's in fear for her life? That's not reasonable. So she tells the 911 operator that she is so afraid of these children. She's in fear for her life from these children. Does she run into her house, barricade her house that very moment? No. About 30 or 40 seconds before she calls 911, she's outside taking more video. But she just tells the 911 operator she was in fear of the children. Ask yourself again, is that reasonable? Her actions are completely inconsistent with somebody being in fear for her life from those children. Still the initial 911 call.
They just get bad for me and bad for me. I'm just sick of these children.
Does that sound like fear of the children, or does that sound like anger?
Are you or anyone else in danger right now?
I locked my doors.
She tells the 911 operator she locks her doors, so there is no danger. Those doors were still locked. That door was still locked and deadbolted when Miss Owens comes over. Now she says she was in such fear of these children, in fear for her life, based on what she told the 911 operator. But there's a chain up there on the door as well. Does she activate that chain? She does not. She doesn't add that 3rd level of security. Why not add that level of security if she was truly in fear for her life from these children?
Why didn't they stress that she lied? So she told 911 she locked her door. She told the detectives she wasn't sure if she locked the door. She wasn't, I don't know. There were some discrepancies in the retelling of her story between the 911 calls, between the first interview and the second interview. False statements, lying, whatever you want to call it. At the end of the day, I don't know. I'm looking at the chat in Law and Crime, and it's kind of going either way. I don't want to say it's 50-50, but I'm looking at the comments and people are kind of like, it looks like it's going either way.
If she's in such fear of this 9-year-old child, does she take the chair that she says that she places under the doorknob and put it there for added security? No. Because again, she's not in fear of these children. She's angry. She had to walk right by that chair and go to the bathroom like she said that she was when the pounding and things started. So we know from her interview that when this pounding and yelling began, she was in the bathroom. She hears this pounding and yelling, and she is so afraid, she goes and washes her hands. She tells you that the pounding and yelling stopped. Like it would stop if somebody is banging on the door, come out, and there's a pause for the person inside to come to the door or to react or acknowledge. Then when there is no reaction or no answer to the door, the pounding starts up again and gets louder. That is the complete opposite of somebody who is trying to get into the house. Again, there's no evidence that Ms. Owens was trying to get into the defendant's house. If she wanted to, she had every ability to do so. But she's banging, come out, pause and wait, bang again. And then the gunshot happens. If she wanted to get into the house, why not check the sliding glass door? Why not continually bang?
Thank you. That was what I said. Like, why would you try to bust down a metal door when you can just break some glass? Like that was the stupidest argument I've ever heard. And nobody if there's a reason, you think if Susan called for 911 and the door is locked, that they're not going to reasonably shatter the glass to access the dwelling to get to her. They're not going to say, well, you didn't answer the door and the door was barricaded. We didn't think to break the glass. Like, come on. She went to the glass. If in fact she actually went to the glass, she knocked on the glass and she saw you were in there, or she saw whatever, or knew you were in there. She knocked on the glass like, hey sis, I'm outside. Like, you called for me. You rang for me and now I'm coming for you. I'll just go to your door. You go to the door. Do you think that if AJ saw Susan standing there with a gun, let's just say Miss Big and Bad wanted to be Miss Big and Bad, right? You went to the bedroom, you got the gun. AJ's at the glass and sees your crazy ass with the gun. I think AJ would have been like, you know what? I'm out. Then Susan probably would have shot her in the back. But don't you think that most reasonable people would be like, oh shit, she's got a gun. I'm out of here. Bye. But you wait till she goes over to the door. Now you're scared. Why didn't you go to the window and be like, look, AJ, I'm armed. I've got a weapon. Or I guess she wasn't obligated to do any of that. Whatever. We'll see what happens. This is hurting my brain. All of the opportunities that Susan had to not be a murderer.
None of that happened.
Susan doesn't have to be a murderer today. But at the end of the day, no matter if she's found innocent or guilty of manslaughter, you still killed a woman. You still killed a woman who was defending her child, and shame on you.
Muriel Rodriguez, who said none of that happened. She was banging. I mean, she was banging hard. State never tried to hide
even if they find her not guilty, doesn't mean it didn't happen.
that. And I never tried to suggest otherwise. She was banging hard. As we talked earlier in my first closing, that the defendant she's not required legally to retreat because she is in her own home. So in order for her to claim and argue self-defense, she doesn't first have to retreat. But her actions inside the house are relevant to consider the degree of fear, the reasonableness of her actions, and the imminence of this perceived threat. So what do we know? When the banging and yelling starts, she's in the bathroom. This is based on her own words in her interviews. She doesn't shut and lock her bathroom door to put up another barrier between herself and this perceived threat. Instead, she leaves the confines of that additional safe space and walks towards the kitchen, towards the door. Does that sound like someone who is afraid for her life? Of course she's not, because there's a big metal lock at the door standing between her and the knocker and the yeller.
If you're going to use a gun, they're telling you you're using it because you want to shoot it, right? So when she left to go get the gun, she went and got the gun because you intend to shoot it. Why have a gun in your hand to protect yourself if the intent is not to shoot, right? You don't go get a gun to go play. You went, got the gun because you made a decision that you were going to the potential was there to use it, and she used it.
In her interview, she admitted that the first words out of Ms. Owens' mouth were, "Why do you speak to my children this way?" Not, "I'm going to kill you. I'm going to come into your house." Why do you speak to the children this way? When the yelling starts, she doesn't go find her phone that she had 2 minutes earlier when she just hung up the phone with 911 to call again. Instead, she goes to the bathroom to wash her hands. Ask yourself, how truly reasonably terrified is she? The banging starts up again and she goes to her bedroom. She grabs the gun from her bedroom and she doesn't grab the 22, the Ruger, the little plinker that she called it. She grabs the more powerful .380 Remington firearm. She doesn't shut and lock her bedroom door where she is with the gun to put up another barrier between her and this perceived threat in case by some chance that she truly believes that Ms. Owens is going to come into her house. Now she has another barrier to protect her. She doesn't do that. She doesn't walk around the corner and point the gun, ready and waiting. No, she doesn't do that. Instead, she leaves the additional safety and security and that additional barrier that she could have put up and walks towards the door. Walks towards this perceived life-threatening threat. She says she walks up to the kitchen table. She raises her firearm, points it at center of mass, where a person would be, and pulls the trigger. One shot, not a panic flurry of gunfire, one controlled, precise shot, a kill shot. Ms. Sizemore told you that the defendant, there's evidence that at the time, right before she shot, the defendant said that she heard a crack in the door. You will listen to both interviews and the 911 call. You look at the transcripts. If you want to listen to them again, you have every right as a jury to listen to those interviews again. Nowhere in those interviews does she say anything such as, "I heard the door breaking, I heard the door cracking before I fired." If you want to listen to them again, you have every right to do so. There is no wood splinters on the floor. There's no new damage to the door frame. There's no wood hanging off when the deputies get there and the crime scene investigators examine it. There's no evidence whatsoever to indicate that there was a crack before the gunshot took place. You heard from Josh Wright and Toby Terpstra. They collectively created the diagram as well as the digital animation. And using the diagram created by the defense, before we do that, Catherine Medina, there was discussion about Catherine Medina doing the trajectory analysis and how that she didn't calibrate certain things. Her role was not to do a full-blown trajectory analysis. She's told you she doesn't have the training and the experience to do that. Her goal was to create a general representation of the trajectory. And even Josh Wright said, based on what she did, it may be a little larger cone of error, but her job and what she did in her representation was a good representation of where the defendant would have been in the path of the travel of the trajectory of the bullet. But take the diagram provided by the defense as true. Who fires a gun like this? She's trained. She's gone to the range. She's practiced. I think in her interview, she said she's watched videos of how to properly shoot and things like that. She even demonstrated in her interview that she held the gun like normal people hold the gun. People don't hold the gun over your head like that. That's the representation provided by the defense. That is inaccurate. That's not reasonable. People don't do that. In order for the gun to be brought down lower, she has to advance closer and closer to the door to maintain that trajectory line. Now, ultimately, does it really make much of a difference where the defendant is standing in her house when she fires? Not really. Does it matter if she's standing right by the kitchen table or if she's standing a foot or two up or a foot or two back? Not really. It doesn't change the facts in this case. What's important about where she's standing is, assuming she's even standing where she says she was standing, what's important is after she gets the gun, she's approaching the door. She's walking towards whatever this life-threatening threat that she thinks there is. She's approaching that threat. That is inconsistent with somebody who is afraid for their life. That's unless you're a law enforcement officer or military or firefighter, most people don't approach the threat. They don't run towards the threat. You heard and saw the video reenactment created by Mr. Terpstra. He admitted that that was based on the defendant's version of events. The video and the way he went about creating it, it was pretty cool. It was neat. But ask yourself, what does it add to this case? It shows Miss Owens banging on the sliding glass door. Well, we know that now, and Gary Rodriguez told you that. It shows the defendant, or Miss Owens banging on the outside of the defendant's door. Well, we know that happened too. It showed the defendant walking towards the door with her gun raised and firing a shot through the door. We know that happened. And it showed the shooting of the projectile, the bullet, through that closed door and hitting Miss Owens. We know that happened. Now, he took some artistic liberties by making the mirror shake and the door shake, and he did that on his own. He's basing it on the defendant's interview, but he decided how to make that happen and how to artistically represent that to represent the degree of force that the defendant said she saw. That's not evidence. That's a representation of his artistic representation of what he thinks the defendant meant and what the defendant said she saw. Again, the video was cool, but it really doesn't add anything to this case. So after the shooting, we hear she makes the second 911 call. And we heard during the first couple minutes of that second 911 call, she's crying. She's upset. Of course she's crying and upset, ladies and gentlemen. She just fired a shot. She knows she shot somebody and realized the gravity and the implications of what her decision was. But notice how her demeanor changes very quickly during that 911 call when she starts talking about children.
Susan keeps trespassing over here. They're bothering me and bothering her. That's fucking up stop. See, her boys were here earlier. They keep using their garbage all around the house. And then I told them to take the crap away, get the fuck out of here.
That's after she fires and after the first initial minute or two of her crying. She's still angry on the 911 call. You saw Deputy Barbosa's body-worn camera when they had first made contact with the defendant. That happened right after she hung up with 911. She wasn't hysterical. She wasn't bawling her eyes out. She was calm. She was cool. She was collected. I think she asked to go in and get water and asked for something to be done with the cats. And look at her demeanor within minutes of being placed in the patrol car. She's, again, not crying. She's not hysterical. This goes to the reasonableness of her fear. Deputy Welfenberg described her demeanor as indifferent. As I said earlier, ladies and gentlemen, the law requires the threat of death or great bodily harm to be imminent before deadly force is used. There was no imminence at the time she fired that gun. The word imminent is very important. It's included in the law and the instructions for a very important reason. In order for the defendant to lawfully use deadly force, the threat to her life had to be imminent, had to be ready to happen, had to be staring her in the face such that she had to act at that moment to protect herself. Now, some of the defendant's medical records were introduced, and there's no dispute that she has those medical records and she has some medical conditions. And if this was a situation where Ms. Owens broke down the door or broke that sliding glass door and was coming at the defendant, those medical records might be relevant because her physical ability to actually engage in a fight could be relevant to this case. None of that happened. Why? Because there's a big door standing between the two of them that couldn't be breached. The defendant knows what imminent means. You heard in in one of the interviews that she did, she gave an example to the detectives. She said, imminent danger is like when a 4-ton truck is coming straight at you and they are swerving with you as you try to run away. That's a very different situation than somebody banging on the outside of a secure door and yelling with no ability to enter. Ms. Owens is not a 4-ton truck. She was not coming at the defendant when the defendant fired. She was not swerving to try to get to the defendant as the defendant ran away. Ladies and gentlemen, the defendant didn't have a half second to process this. She had minutes to process this. All the decision making that we just went through in the beginning of the part of my closing, all the decisions she made, where she went, wash your hands, go here, walk around here, go to the trash can, grab a more powerful weapon, come and approach the threat and fire. And then she had the presence of mind to go back with the gun she just used to shoot and put it back in the trash can underneath the smaller .22 Ruger. Ladies and gentlemen, as a society, we do not condone shooting another person because of an act that may occur in the future, or because X, Y, and Z may happen, and I may be forced to defend myself. Law enforcement officers are not allowed to go around shooting people because the person may have a gun, may pull it out, may threaten the officer with it.
That's sustained.
The danger has to be imminent. Not, it could happen. It may happen. If 2 or 3 or 4 things occur, it may happen. That's not imminent. The defendant does not get to shoot Ms. Owens because Ms. Owens may somehow manage to get through that door and may then decide to attack. Because before that door is actually broken in, Ms. Owens has no physical ability to cause any harm whatsoever. That is the law that we have agreed to live by. Because there was no imminent danger when the defendant pulled the trigger, her decision to shoot and kill Ms. Owens was not reasonable, and it was unlawful. We talked in jury selection that your role in this case is to determine whether or not the defendant's actions on the night of June 2nd, 2023 violated the law. It is not anyone's role here to determine if the defendant is a good or a bad person. And this decision that you're about to make should not be based on sympathy to Ms. Owens, her family, simply to the defendant. Your decision in this case should be based on the law as the judge reads it to you and how the facts that you know that have been proven apply to that law. And as I said when I started this, the facts really aren't in dispute. Ms. Owens is banging on the door yelling. She's angry. She's angry about how the defendant treated her children. Ms. Owens is not trying to jiggle the doorknob or break down the sliding glass door, break the window, not trying to get into the house in any way. Law enforcement was on their way. She gets her gun. She fires one shot, center of mass, which kills Ms. Owens. The judge will tell you that it's your duty to determine if the defendant is guilty of manslaughter. If you find the defendant guilty, it is his job to determine what the proper punishment or sentence should be, not yours. I submit to you that if you are back in the deliberation room talking about the case and you're thinking, what's going to happen if she is found guilty? You've already made your decision that she is guilty because that's what the evidence has proven. After you boil down the facts and circumstances, you really have to answer one question. Like I said when I started, following the laws that we have agreed upon, is it okay to shoot through that closed, locked, deadbolted metal door as someone who is banging on it and yelling, but posing no imminent threat? Based on the facts of this case, it's not okay. Based on the law in this case, it's not okay. Just being afraid is not enough. Just her saying she's afraid is not enough. Using that ordinary, average, everyday person standard, you have to ask yourself, were her actions reasonable? Was her decision reasonable? And was that threat imminent? Was it about to happen right now? Ladies and gentlemen, the facts of this case have proven her decision was not reasonable. The decision wasn't made while acting in necessary self-defense. It was not justified.
My bad, sorry.
Because of that unlawful decision, Ajike Owens lost her life. We ask you find the defendant guilty of manslaughter with a firearm because that's what the evidence has proven beyond any reasonable doubt, and that's what the law requires. Thank you.
Ladies and gentlemen, if you listen carefully, have your final instructions, okay? Weighing the evidence.
Okay, I'm not mad when he came back. So the prosecution, I mean, they had the opportunity. In some states, like you have the defense would have been able to come back too, but I guess in Florida, prosecution has the last word. So good. I do think that he did do at least a little bit better job packaging it all together at the end. I'm going to say what I've been saying. I don't think for 1 second, I just, maybe in the beginning, so maybe we'll watch a little bit of day one. That's what I was trying to pull up and lagged a little bit. Maybe like I would have loved to have heard on that day, Ajike Owens came home from work. She works 8, 9, 10 hours a day. She's confronted again by her children who had another dealing with a very unstable adult across the street who is constantly talking to the kids, constantly has an adversarial relationship with the children. And this mom went across the street to go and have a conversation with someone who told her to come have a conversation with her. After hearing that a roller skate and all of the things and the iPad that she works hard for is now missing, and the word is that she has it. I don't think that there's anything wrong with going to somebody's home and knocking on a door. The fact that people feel like someone can't knock on your door, that's crazy. All right. If you want to live out in the country and you have a private driveway and no one can come to your door and no one can go into your driveway, that's one thing. But if you live in a public neighborhood, someone can walk up to your home. The perception of no trespassing, therefore I can shoot out my window, drop cinder blocks, shoot through doors, all of those things is absolutely crazy. Like it makes this type of a case to me, it's almost precedent setting that you don't even have to know what's going on the other side because you're scared. You can do that. And we know that in recent cases, there have been people who've lost their lives knocking on doors. And that just should not be the case. People, if you're scared to live in your neighborhood, don't live there. You can't blame the people that live in your neighborhood when you chose to live in the neighborhood. Like when they said that this was an unsavory neighborhood, well, damn it, Susan Lorincz is unsavory. She's a woman of a certain age who thinks it's a good idea to reprimand other people's children. And the connotation that these kids are yelling and screaming, they're playing. They're playing. Why is play now yelling and screaming like it's a bunch of bad kids? And because this might be a low income neighborhood, these are unsavory people. I'm sorry. I'm not buying it. She's not unsavory, but the people that live in her neighborhood are unsavory. And why are they unsavory? Because they are low income. So now all low income people are bad people and they don't deserve to have a neighborhood where kids can go outside and play and the kids got to be quiet outside. Like, come on now. This is just insane. This is absolute insanity. Um anyway, uh okay guys, they're at lunch. If you want me to keep the chat up, I will. I don't know if they'll be back after lunch. It's quite possible they've already made a decision, but like he said, if you're thinking for a minute, what what could this look like if she's convicted, then like he said, in your mind, that and that would be maybe beyond a shadow of a doubt, is that she's innocent. So he gave that instruction. Um and we're going to see what happens. Anyway, guys, I'm going to go. I'll keep this on and maybe they'll be back in a little bit. You never know because we're coming up on an hour. So I don't know. Let's see. And I'm going to leave the chat up for you guys. Okay. I'm watching the chat now. Let me see if I can pull up day one and I can do that. So we'll flip it to another. If you guys want to watch some of day one, then let me get that pulled up. Just a second. Okay, just so you guys know, we are replaying a little bit of day one of the trial. Um, okay, day one. All right. As the jury is still deliberating, I've got the live feed going. So if they come back while we're watching, then I will pivot. Okay.
Yeah. Everyone ready to go?
Yes, sir.
I'm gonna,
Let's bring the jurors back.
since we have the luxury of this being a repeat, then I'm
Right,
gonna.
the first one is just not a minor issue.
Correct.
Okay, no problem. Stay ready for the first witness.
Before we do that, Your Honor, by stipulation between the parties, the state will move State's Exhibit A into evidence as State's Exhibit 1. It's a photo book containing relevant photographs as well as a map.
Any objection?
No objection.
All right. State's Exhibit A by stipulation will be in evidence of state's number 1.
State would also move into evidence State's Exhibit K, the stipulation as State's Exhibit 2, and ask the court to read that stipulation.
K, you said?
K.
K.
Yes, sir.
Any objection?
No, sir.
State's Exhibit K will be evidence of State's Exhibit number 2. You want me to read the instruction on stipulations?
Yes, sir.
Do you see this guy?
Raise your hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. Please introduce yourself to the jury. Good morning, sir.
Morning. My name is Franklin Bias.
Franklin Bias?
Bias Cologne, yes, sir.
Okay, I apologize.
So,
What do you do for a living?
well, right now I'm just working in construction. Just do small houses, sir, here and there.
Were you in the military?
Yes, sir.
For how long?
About 13, 14 years in the service, sir.
In what branch?
Army.
Thank you, sir.
Yes, sir.
Do you have any prior law enforcement experience?
Yes, sir, I do.
What would that be?
I used to be a federal agent, border patrol agent,
For how long?
5 years.
Where do you live?
It's sorry, I'm bad with addresses. Since I quit the law enforcement, it's like 1686 107. It's Quail Run, the property. That's what's called. If I'm not mistaken. 107th Lane. Yes, sir.
Let me direct your attention back to June 2nd of 2023. Did you live at the same place back then?
Yes, sir.
Okay. Do you have a son?
I do.
What's his name?
Yedian Bias.
And how old is he?
About 13 years now.
Do you know a woman by the name of Susan Lorincz?
I've heard it. Yes, sir.
Do you see her in the courtroom today?
Oh, yes, sir.
Can you please point her out and tell me what she's wearing?
She's wearing a black suit, if I'm not mistaken, and purple on top.
Your Honor, may the record reflect the witnesses identified the defendant.
It will so reflect.
What was your relationship with the defendant?
Can you define relationship? I'm sorry. I'm
Sure.
just.
Were you friends? Were you acquaintances? Did she live near you?
Yes, sir. She was my neighbor across an open field, pretty much.
Did you ever have any kind of real meaningful interaction with her, like socialize with her?
No socializing, no, sir.
Did you know Ajike Owens, AJ, the victim in this case?
I did interact with her a few times. Yes, sir.
I'm showing you photograph 1 of States 1. Do you recognize that photo?
Yes, sir.
And who is that?
That is AJ. Yes, sir.
Did you have any real meaningful interaction with her? Meaning, were you a close friend of hers, acquaintance, or did she just also live in the area?
She just lived across from the street where I was at staying. Yes, sir. But no close relationship, nothing like that.
Did you know her 2 oldest children, specifically Isaac and Israel?
Yes, sir. I did.
How did you know them? What was your relationship with them?
I used to play with them on the open field around the neighborhood.
About how old was Isaac, or is Isaac?
I mean, just by looking at them, like I don't know exactly their age, but I mean, we're looking at Israel and Isaac, maybe around the same age as my son.
Okay.
Yes, sir.
Was one older than the other?
Yes,
Israel
sir.
or Isaac?
Yes, sir.
Do you know who was older?
Isaac was older.
Even like substantially older, or just a couple years?
Maybe a 4 or 5 years difference, maybe.
Where was your residence? Where did you live in relation to where the defendant lived?
So my unit, it's there's 4 apartments per unit. So it was my unit. So I'm on apartment 2, unit 2. There's an apartment. So if I'm in my house, if you're looking at it, on the left side, there's another unit, and then you have the open field, and they have Miss Susan.
Let me make this a little easier.
Yes, sir. I'm sorry.
That's okay. Let me show you
It's kinda hard to explain, I'm sorry.
Does this aerial Google Map image or Google Earth image accurately reflect the area you lived in?
Yes, sir. So where the sorry, it's kind of hard to tell. I mean, not to tell, but to explain it still, where the white vehicle, there's a white. That's where the defendant used to live. Yes, sir. Right there.
And
There's
said Miss Owens lived across the street. Is that accurately reflect the
Yes, sir.
you lived in?
Yes, sir.
And you mentioned a white vehicle.
That's where I'm at. Right. Yes, sir. That's my apartment.
This right here, this area?
Yes, sir.
You mentioned an open field that you and the children, you would like monitor the children.
Yes, sir. In between myself and defendant's resident. Yes, sir.
This area right here where the pointer is?
Yes, sir.
Between where you live and where the defendant lived?
Correct.
Okay. Showing you photograph 3 of States 1. What does this generally show?
Yes,
That's-
this
that's
is
our
jump
neighbor.
rope guy. This
Yes,
is the guy that played with the
Would your
kids
house
in the
be
field next to
100%
his
facing next to
apartment.
this side?
So my house, from that perspective, is going to be on the right side of that picture, kind of like, well, it's
Try this one. It's the photograph 4 states 1. What does this show?
that's where she lives or used to live. Yes, sir.
She,
The Miss Susan
okay, Miss Susan.
on the right side.
Where would your residence be facing, looking at this picture?
So I would be. So the open field is going to be right to the right, next to that unit, and then I'll be on the other side of the the open field.
I'm showing you photograph 5 of states 1. Moving a little bit panning to the right. What does this show?
That's the open field. You can see my unit and her unit as well.
Is your unit over on this side?
Yes, sir. There's so unit 1. That's the first one you see there, right at the corner, and it'll be unit 2 right next to it.
Does this also show that open field that you have talked about?
Yes, sir.
Would the neighborhood children, along with Miss Owens' children, Isaac, Israel, and her daughter Africa, play in that open field?
Yes, sir.
What kind of things would they do in that field?
We used to play all kinds.
Objection based on our motion.
Approach.
Your Honor, can they not talk about playing? We just want to focus on the angry
Overall
black
objection.
mom. We don't want to talk about the kids playing double dutch, jump rope,
All kinds of
dodgeball,
outdoor
and things
games,
of that nature. We just
volleyball.
want to.
There's another
We just want to
game.
make the mom
I
look
used to call them
bad.
out by numbers. That's jump ropes. I mean, all kinds of outdoor games. Yes, sir.
Were there times that you would be out there with the kids when they played?
Most of the time, yes, sir.
Was there also a basketball hoop on the other side of the street in this area?
Yes, sir. So the basketball hoop will be right behind. It's if you're looking at that picture, it's going to be on the left side of that picture,
Okay, so
across the road.
I'll show you photograph 3 of states 1 on the opposite side of the road, kind of where that white van is.
Correct. Near or yes, sir.
Do you remember a no trespassing sign near where the defendant lived?
Yes, sir. Not just one, a few of them.
When the children would play in this open field, would they sometimes get loud?
Yes, sir. I think not sometimes.
Y'all,
I
the
think
judge is
every
back
time
at
we
his
used to play.
desk. Hold on. Oh, hold on. I'm getting to it. Oh, shit. Hold on.
Can we listen to both 9/11 calls? Any objection to that by anybody?
No, Your Honor.
All right. And if I don't know,
Ooh.
I believe I asked, but there was no objection to the instructions that I read. Is that correct? No one objected to the instructions
Correct.
as read? Actually, I think I mentioned it, but I can't remember. Let's bring it back in. Can we get that queued up or?
That's right. I'll make sure the line is working correctly.
It's the discrepancies for me. If they want to go back to listen to the both 911 calls, it's the discrepancies for me. So yeah, this might be a good sign.
Mark, this is question number 1. For you can also only part of the paper. So some people use the whole paper for just a simple question. Welcome back, ladies and gentlemen. It's my understanding you have presented us with a question. I'm going to read the question into the record. The question is, can we listen to both 911 calls? And the answer is yes. And we'll play them for you now. Again, as I told you before, you can listen to them as many times as you want. If you need a volume up or down, let me know. And we'll play them for you in just a minute. And then we'll go from there, okay? If you want to do them again, you can always do that. We're playing on the first one first.
911, what is the address emergency?
1662 Southwest 107th Lane.
All right, and then can you repeat that for me one more time to make sure I have it correct?
1662 Southwest 107th Lane.
All right, and what is your phone number in case you get disconnected?
352-777-5919.
What is your name? I'm sorry, you said your name was Susan?
Yes.
And what was your last name, Susan?
Lawrence, Lornc.
All right, and tell me exactly what happened.
You got kids trespassing down there, leaving all the toys around. It's just getting in them, just being absolutely obnoxious. I went into the roller skate over to the other side. The kids were going to beat you up for that. And his mouth walks to me.
All right.
That was in my own head.
All right, is he out there right now?
Yeah, there are several kids out there right now. I'm feeling for my head. I'm very scared.
Okay. All right, and what unit number are you in?
3.
Unit 3, okay.
Yeah.
Do they also live in the same building?
No, they're going to cross the street.
Okay. Was there any weapons involved? How many people are involved?
Earlier there was about 20 kids out there swimming around. After the swimming room, now there's 2 boys.
3?
Yes.
Okay.
And a big thing, I took his iPad and all this other shit was just in the street. The other thing I was looking was up over street, and I don't want to get hanging with these children.
All right, and are they white, black, Hispanic, or Asian?
I think one is Hispanic, the other 2 are black.
All right, and then the Hispanic, how old would you say he is?
That's wrong.
12, all right. Were they all about the same age?
They're black.
All right, and then the Hispanic male, what is he wearing?
He's got, I think, a t-shirt and pants on.
Do you know what color t-shirt?
No, I couldn't tell him that.
Okay.
I just don't like them coming around my house. They've been coming onto my deck, my patio, and it's telling me, get up, get up. And I'm watching TV and stuff. They have no business over here. There's no trespassing signs. I don't like the kids threatening me that they're going to beat me up, that they're going to get someone else to kill me. And this is just ridiculous.
Are you or anyone else in danger right now?
I locked my door.
All right, who is in charge of the property? Okay.
Yeah. Now, look,
do want you to avoid that person and then keep your doors and windows locked. An officer will be dispatched as soon as possible. Do you want the officer to contact you?
Please, yes.
All right.
Because what's going to happen is mom's going to go out, wait for the officer on one and say, oh my God, I was threatened with this, which just isn't true.
All right, and then I'm going to go ahead and let you go, but please call us back if anything changes or if you get any further information or if they do leave, okay?
Okay, thanks.
Thank you. All right, bye-bye.
Bye.
Did anyone want to hear that call again? Oh, does anyone want to hear that call again? Okay, we'll move on to the next call.
911, the address of the emergency. 1662 Southwest Repeat that address for me to make sure I have it correct. 1662 Southwest 120. Okay, what is your name? Okay, what's going? Take a deep breath for me. Calm down. Because someone tried to break down your door, is that correct? Yes. Yes, the woman was screaming and yelling. She was trying to break the door. Okay, was a female? Yes. I didn't know what to do. I got my gun and then shot at the door. Oh my God. Okay, you said you shot at the door, is that correct? Yes, I shot at the door because the window popped up. I thought it got away and she wouldn't. Just excited to say it. Okay, where's your gun now? It's in my bedroom. I didn't have the door. This is the woman who attacked me. Okay, do you still see the subject? I don't know where she is. I'm still in my house. I didn't open my door to her. Is it just only you in the home? Yes, it's just me. Okay, I just need you to lock all your doors and windows, okay? I have. Okay, I'm going to stay on the line until the deputies get there. Okay. Thank you for come and kill me. And did you know her? Yes, she's come after me several times because of her children. Her children keep trespassing over here. They're bothering me and bothering me. They won't fucking stop. Is she a neighbor? Yes. Do you know where she lives? She lives at 1663 Southwest 107th Lane. 1663 Southwest 107th Lane, is that correct? Yes. Okay. Do you know her name? AJ Owens. I'm sorry, what was her first name? AJ, A-J-I-K-E. Okay. Just let me know when you see the deputies. And like you said your gun is put up in the bedroom. Yes, is that correct? Okay. Yes. Okay. Jesus Christ. And what unit number is for the subject? I don't know. I don't know if she's one or two. Okay. She's an old broken down Honda or something, a white car in front of her house. It's all garbage. You said a white Honda? Yes. And then she has a new Acura. Okay. You're doing good. Just take a deep breath for me. You do have deputies on the way, okay? Okay.
And do you see the male subject or you just see the female?
See, the boys were here earlier. They keep using the garbage all around the house.
Okay.
And then I told them to take the crap away, get the stuff out of here.
Do you know where the boyfriend is now?
I'm sorry?
Do you know where the boyfriend is now?
No.
Okay.
I'm not standing outside now.
And we do have deputies getting close, okay?
Okay, I think they're here now. I see the light.
Okay, if they're there, I'll go ahead and let you go.
Okay, thank you.
You're welcome.
Bye-bye.
So anyone want to hear the video, the 911 call again? Okay, you're welcome to listen to as much as you want. If you want to listen to it again, send us the same note. We'll play it for you again, either one. Okay. You return to your deliberations. Thank you very much.
AJ had a boyfriend. I don't know that that was the kid's dad per se, but she had a boyfriend. And like most men, they're not running, and he's not, let's say he's not the father. I'm going to just assume. If he's the father, he's perfectly within right to go and talk to someone who's addressing his kids, but she went to go handle the matter. I'm assuming maybe either because it was a woman to woman and or not the father, two plausible reasons, but she had a boyfriend. I don't know that the boyfriend lived there, but the boyfriend may have been in the midst on that day. I don't know. I don't know enough. I don't know that they really articulated AJ's side of the story well, as far as who she was as a woman, a mother, her household, all of the things. That's what I'm a little disappointed about, but anyway. Okay, guys. The live feed is continuing and we'll go back to day one. Okay. I don't know why they're clearly deliberating at this moment. They are listening to the 911 calls. I don't know. I don't even know what to say. I feel bad at this situation. I definitely feel like it's I'm afraid of Black people, but I live in this diverse neighborhood and I'm afraid of my neighbors. I don't even want to say I'm afraid of my Black people because it was all different types of people living in the neighborhood, Black, white, and maybe even more. I don't know. But it's like, if you don't want to live in a diverse area, don't live in a diverse area. And if you can't afford to live better, sis got to do better. I don't know. I have no idea. But it really, the low-key put downs of the neighborhood, calling it unsavory when this is what sis could afford. And I'm not talking about AJ, I'm talking about her. You know what I mean? Like, I don't get it. This is a very interesting take. Like, Susan just fell from the sky into a neighborhood that she's just not part of. Sis is part of this neighborhood. Are you kidding me? She was there before the Owens got there. And she seems to know all of her cars. She seems to know she has a new car over there. All of her details. She got a boyfriend. She got all of the things. And I don't know. It's unfortunate. I hate this for AJ that she kind of fell into this loop with this lady. And I mean, I wish they would have talked a little bit about the purchasing of the guns and how the purchase of the guns was on the heels of a situation. And to me, there's a direct correlation with her going to the store to go buy, these guns based on how she felt. revolving around these incidences. And to me, I feel like she went and got those guns with AJ's name on them. Anyway, all right, let's pivot back to this for a little bit. But they're working, and maybe they don't, maybe the intent is that they want to get this done before the weekend.
They were loud. I was loud as well with them. I was a kid.
And would you agree with me that there were times that the defendant would come out and kind of voice her displeasure about the children being here and being loud?
Yes, sir.
Your Honor, when we approach on all these issues.
And why is it being loud? Why can't it just be playing? This chick over here, I can't stand her. I'm sorry. Miss Bob. I don't like Bob. Sizemore, is that her name? And then I don't like her team, period. Ponytail, Bob, and Creepy Yoki. Creepy, Bobby, and Ponytail all need to have a seat. We're going to fast forward through these parts because we have the luxury of this has already happened. So we can fast forward through some of this.
Go forward after that question.
Mom's profile, grandma, AJ's mom in the middle with the, she's got the braids and the swoop. She reminds me, doesn't her profile give you Cheryl Lee Ralph? She's a very pretty lady. She's giving Cheryl Lee Ralph.
Would there be times that the defendant would express her displeasure with the children being there and being loud?
Yes, sir.
Okay. I want to take you to June 2nd, the day of the shooting. Were you playing with the kids in that open field that day?
I was. Yes, sir.
So jury deliberations are now, I think I pinned a comment. The jury started deliberating at 12:07 and they just came back and re-listened to some 911 calls. So we are, let me put this banner up because I'm sure, we're watching a little bit of day one. So yes, the jury is currently deliberating. They just came back with a question and they asked to listen to the replay of the 911 calls. So we did listen to that, and now we're on day one, witness one.
And you remember about how many kids were there playing? One or two or more than that?
Oh, no. It was, at least 8 or 10, 12, 15 kids sometimes.
Were the kids being loud?
Yes, sir.
Did you see the children that day on the defendant's property or going onto her property?
No, sir.
While the children were playing in that open field, did there come a time that the defendant came out and began to record you and the children?
Yes, sir.
Were Israel and Isaac playing in that field with you guys?
Yes, sir.
Did Israel have a tablet with him?
He did.
Okay.
Well, either a tablet or a phone, something. He had something.
What did he do with this tablet?
Well, I was playing with the kids, and whenever he approached me, because I was in the middle trying to guide, I had him all divided in two teams. So he said, I was literally paying attention to the both team, and then Israel, he asked me if I can watch his.
Objection, Your Honor. Hearsay.
So we're ruled.
So Israel asked me if I can watch his phone or tablet. And I'm like, I cannot because I'm paying attention to everyone else. I'm calling down numbers. And he's like, I'm just going to place it here. I'm going to leave it here. I'm like, you got to be responsible for your own things. I was right at the in the middle of the field. And then he just left it there. I just kept playing with the kids.
Do you remember where he left the tablet?
And right in the middle of the open field, yes, sir, where I was standing, facing towards my unit. If you're looking at the picture, I was facing towards my unit.
Did there come a time that you left the open field and went back to your house?
I did. And once we got done playing and everything, and I got tired because I behaved like a kid, but I don't have the energies. I went back to my apartment. Yes, sir.
Do you remember, was it getting dark? Was it still light out when you did that?
It was about to get dark. Yes, sir.
When you got back to your apartment, what did you do?
I started playing on my phone, being on Facebook, what everyone does today's day, wasting life.
For about how long did you do that until something else irrelevant to this case happened?
Maybe approximately 30 minutes.
And after that, about 30-minute period of time, what happened?
I heard like a firecracker, which in my military experience, I thought it was a firecracker because it wasn't that loud. It sounded weird, but then I'm like, no, it can be a shot. It's gonna be a firecracker.
So what did you do after you heard that sound?
I didn't do anything. I just went back to my phone and then I heard banging on my door.
When you heard the banging on your door, what'd you do?
I opened it up. I see my son panicking, screaming, and literally just panicking. He couldn't talk.
Is that your son Uriel?
Yes, sir.
When he was in that condition, did he say anything to you?
Objection, Your Honor, hearsay.
So ruled.
He said she got shot. She shot her.
Okay. At that time, did you understand what was happening?
Negative, no, sir.
What'd you do?
I try to calm him down to try to gather more information. If someone got shot, I mean, military experience, I'm like, well, I need to hurry up to see if I can help someone.
I'm showing you photographs. 6 of states, 1. What did you do when you went outside?
I went outside. I went towards what we as a law enforcement and everything we have stimulus. I went where the noise was. So I went towards the noise right at the corner where near the basketball hoop was at, right at the corner. And I heard everyone screaming and the kids crying, Isaac and my mom. One of the neighbors came out telling me she got.
Before you go into anything what the neighbor said, that's okay.
Sorry.
That's okay. At some point, did you go over to and locate Miss Owens?
I did.
Okay.
After the fact, yes, sir.
Where was she located? Can you see where she would be located in this photograph?
It's going to be where the headlights are pointing at. The lights is near the tree, that big tree that's there in the open field.
Is that the big tree you're talking about?
That's the tree I'm talking about, yes, sir.
Okay. What did you do when you arrived by Miss Owens?
I immediately keeping an eye on Miss Susan's apartment just in case. I mean, you never know. I mean, I'm just situational awareness.
What did you do to hurry up?
I started scanning for open wounds, because I heard she got shot. So I was just scanning for open wounds to try to help her out.
When you were next to Miss Owens, did you notice any weapons around her? Any gun, any knife, any kind of bat, anything like that near her?
No, sir.
Do you have first responder training based on your military and law enforcement experience?
Yes, sir.
Okay. At some point, did law enforcement arrive?
Yes, sir.
And did emergency medical services also arrive?
Yes, sir.
Did you direct law enforcement to where Miss Owens was?
Yes, sir.
At that point, did you kind of step back and law enforcement took over what needed to be done?
Correct.
All right. Did all this happen in Marion County, Florida?
Yes, sir.
All right. Thank you, sir. No other questions, Your Honor.
Cross-examination, sir.
Thank you. Good morning.
Good morning, sir.
Now, on that specific day, the kids had made kind of a mess out there in the open field with their shoes and trash and all their stuff, right?
They had their shoes, yes, sir, on the open field. They had, yes, cups.
Trash.
You could say that, yes, sir.
Okay. And when you heard what you thought was a firecracker, but it was already dark outside, right?
When I stepped outside, it was already kind of dark, yes, sir.
No further questions. Thank you.
Thank you, sir. Any redirect?
No, Your Honor.
Is he excused?
Yes, sir.
Have a nice day, sir. Thank you
Thank you,
very much. You're excused. State ready for the next witness?
Yes, Your Honor. The state would call Mr. Jimmy Cowan.
Is this witness under 18?
Yeah.
Okay.
Do you swear affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Have a seat, sir.
May it please the court. Can you please state your name for the record, sir?
My name is Jimmy. Legal name James.
Guys, I'm keeping an eye on everything. I see the judge, but he's talking to the courtroom, but he's not. Hold on, before we get into it, I'm just going to show you guys what the visual is right. Well, Um, It's the visual. It's nothing really going on at this moment. So I've got an eye on it. So we'll put this witness 2 for the prosecution. We saw pretty much the heavy lift of the defense. So, but this is day 1 prosecution. Okay. So this is witness number 2. I think this is the landlord. Okay.
Elected for the 2021, this was reelected again.
And
I'm not sure.
what
Who
was
is
your
this guy?
occupation prior to being elected to the Marion County as the Marion County property appraiser?
I've worked at the Marion County Property Appraiser's Office since 1992.
Okay.
What is the duties
Okay.
of the
So he's at a property appraisal office.
property appraiser's office generally when it comes to people's property?
Well, we value all property in Marion County, whether it be residential, commercial, do all exemptions for taxable homestead exemption, agricultural classifications, things of that nature. We list and map all properties in Marion County, and we also have a statutory requirement to do all damage assessment when a storm comes through.
You say you list and map all properties in Marion County. Are you talking about parcels?
Parcels.
If you could please explain to the jury what a parcel is.
It's a tract of land or ownership, basically.
All right. And how do you determine that, your office?
We determine it by deed. When a deed comes through, basically whatever the legal description is that's applied to us, that's recorded in the clerk of the court's office, we actually change or put in that person's name. Sometimes it'll be cut outs or combined or whatever the case may be. So it may change what the record was before.
So you create records and maps of parcels based on the information that you receive?
Yes, sir.
Now showing some previously marked States Exhibit B for identification purposes, sir. Can you please take a look at those? Just let me know when you're done.
I've seen all these before, so if you want to ask questions, it's fine.
Yes, sir. And are those records from your office, sir?
Yes, sir.
And to your knowledge, do those records pertain to the addresses of 1662 Southwest 107th Lane and 1686 Southwest 107th Lane in Ocala?
That is correct.
Your Honor, at this time, I move into evidence States Exhibit B at State.
Objection states B, we have evidence that states number 3.
Thank you, sir.
Give the clerk, please.
So I want to go over some of those records with you. Mr. Cowan. I'll wait till the clerk finishes looking at it.
Yes, sir. I don't need to see it now.
I'll let you hang on. States Exhibit 3, sir. I'm ready, Your Honor. States, yes.
Are you on the state or the podium?
The states.
I got it.
So, Mr. Cowan, I'm showing you what is it's like a record photograph included within those records, States Exhibit 3. Can you please explain this to the jury what they're looking at?
Okay, these are ortho images or aerials. What ortho means, basically looking at a rooftop view of the property. So basically, this would be a portion of possibly a subdivision, basically. And there are some green lines that some people may or may not be able to see. I can barely see them from here, but I know they're there.
And we're going to, those are two abutting properties.
Say it again.
Two abutting properties, the aerial photo.
Two abutting, is that what you're saying?
Two properties that are next to each other.
Yes, they're contiguous. Yes.
So now showing you another photograph here. It looks like a parcel number 3577-001-010, aerial photograph of that. Can you please tell the jury which address that parcel number belongs to?
10. That of 3577-001-010 is 1662 Southwest 107th Lane. It'll be all units A, B, C, D probably.
Thank you. So is that a quadruplex, sir?
It's quad. Yeah, quadruplex.
And who is the owner of that building there at 1662?
Okay, based on the records, when this was printed on May 21st, I don't know that it has changed hands or not, but based on that time period, it was Diana and Charles Gabbard, Gabbard.
All right. And if you could please explain to the jury these red lines we see on this aerial photograph.
The red lines would indicate basically the boundaries of the property based on the deed that we received, or it could actually also be from the plat when it was platted.
Okay. That would be the boundaries of the parcel based on the information you're
For assessment purposes, yes.
Okay, thank you, sir. I'm now showing you an aerial photograph with some more red lines. This is for parcel number 3577-001-008. Sir, can you please tell me what the address is for this residence?
The address, site address is 1686 Southwest 107th Lane.
And who is the owner of that residence?
Again, at the time of the printing of this property record card, it was AARA Holdings LLC.
Thank you, sir. And the red lines that we see here again, is this again the boundaries of that parcel based on the information you received?
That is correct. It'd be based on whatever deed came through when it was last sold.
Thank you very much, sir. I have no further questions.
Cross-examination.
Yes, sir. Mr. Smith, can you back it up to?
Yes.
There you go.
Good morning.
Good morning.
So this slide that we're looking at here, so this is actually this red line. This is the property line around that property. Is that right?
That is correct.
Now with this quadruplex, there are multiple porches attached to it, right?
Well, from looking at an aerial, you may say porches, it could be a patio. Let me look and see what we have assessed on it, and this is 10. On that particular one, it's showing patio as the last time we were out there.
So there's multiple patios attached to it, right?
Yes,
So anything that is permanently affixed to that property, that would be owned by the individual that's listed on that parcel?
yes. Anything within the borders of that red that is permanently affixed, asphalt, concrete, patios, the building would be real estate.
So that would include porches or patios affixed to the property, right?
Yes,
That would also include any sidewalks that's within that red line up there?
yes,
That would also include any grassy areas that's within that red line?
Y'all, I thought I heard him say something. I was like, wait a second. There was some movement going on. Okay. Maybe not yet, but I'm keeping my eye on it. I'm on verdict watch for you. Okay. Thanks to a couple of people who sent some cash apps. You guys are so sweet. So thank you again. Let me drop a coin. I've been trying to keep it. This is such a serious day and topic. This touches my heart on some mom stuff. I'm also a Black woman. But you know, to me, I feel like it's been villainized. It's an indictment on, you know, me as a Black woman, but I feel like it's also on some mom stuff. And I hold my walk as a mom closer to me than I care about what people think about my race. This is so bothersome. This is absolutely horrible. Anyway, I just hope that they do the right thing.
Submit another question. The question says, can we get clarification on when the door frame was damaged and how it was damaged and by whom?
So they want to know, they want to know who damaged the door frame. So yeah, they're trying to figure out, did AJ actually really almost come through that door? Because she could have broke the glass.
Obviously, we cannot give them information. So the question is, how do y'all want me to answer? I normally would answer, and you can add or subtract or object, whatever you want. I normally.
Are there even fingerprints to show that AJ even touched the doorknob? Like the perception that she was trying to bust down the door. So they're trying to figure out that question. And if the answer is it was already damaged, the door was already damaged and she did not damage the door, I would hope that there's actual fingerprints as to whether she even touched the doorknob. If she never touched the doorknob, sis, what?
Say all the evidence that has been received in this case. You'll need to make your determination based on whatever evidence has been presented in this case.
I think that's the appropriate answer, Your Honor.
So let me write that out. So
That's fine with the defense judge.
all of the evidence in this case has been presented. All of the I'm going to say we cannot answer your question. Because it's a question of fact. So I say we cannot answer your question because, or just say don't, for any reason, or just leave it at that.
I would just leave it at that.
Okay, we cannot answer your question. Try to get that second phrasing down. I think what I'll say is you will need to make your decision based on the evidence that has been presented.
Yes.
Yes, sir.
Okay. Or admitted. So I hate to give anyone the idea that there's more evidence that they don't know. I just want to say it. So I'll say this. We cannot answer your question. You will need to make your decision based on the evidence that has been admitted.
Yes, sir.
Let's bring it back, please. Everyone's okay with my answer?
Yes, sir.
Okay. There you go. Oh, I need it back. I need to read it.
What was the question? Was it how long has the door been damaged or who damaged the door?
Welcome back, ladies and gentlemen. I have a question here, and I'm going to read it into the record. Let me know if I have it wrong. Can we get clarification on when the door frame was damaged and how it was damaged and by whom? Is that the correct question? We cannot answer your question. You will need to make your decision based on the evidence that has been admitted. All right.
Perfect.
Return to the jury room, okay? Thank you.
The judge is such a nice guy. The judge is really, he's so thoughtful. You know what I mean? I think he really, he's so pleasant, but he's also
We'll go
appears
into
to be
recess
very
once again.
thoughtful, because he really does, and obviously he's a judge, but he does seem to really weigh out both sides and how he's going to say things, and also tries to be super courteous. I think he's such a nice guy. But we've also heard him make decisions, right? So I like him. I hope the jury, I mean, the fact that they're asking questions, I think is a good thing. I don't know. This is maybe they're coming back soon though. Okay, let's get back to the boring property guy. Can we take some, why does he look like Mr. Sneed from The Simpsons? I'm just saying, I'm sorry. Okay, this might be, are they talking to a kid now? Hold on. I think they're going to be done with this guy.
Anything additional? Need to redirect?
No further questions.
Is he excused?
Yes, Your Honor.
Thank you, sir. Have a nice day.
Okay.
No.
Oh, yes, Your Honor.
I'm a pop culturist. I can't help myself. I have a
Sir, raise your right hand. Face the clerk.
Do you promise to tell the truth?
I have a ridiculous knowledge of things that are not important.
May it please the court.
Yes, sir.
Good morning. How are you doing?
I'm doing good.
Yeah? A little nervous?
Yeah.
What is your name?
Ariel,
Okay. What's your last name?
Vise,
Okay. And you also Rodriguez?
yes.
Okay. So how do you say your full last name?
Ariel Vise Rodriguez.
Thank you. How old are you?
I'm 13.
All right. What grade are you in?
I'm in 7th.
So what's your favorite subjects in school?
Science.
Like to do anything when you're not in school?
Excuse me.
Like to do some things when you're not in school?
Yes.
What's that?
Play soccer.
So I want to talk to you about this case, Uriel, and I want to ask you if you know people first. Did you know an Isaac?
Yes.
All right. Did Isaac live in your neighborhood?
Yes.
And did you used to live with your dad?
Yes.
Do you remember the name of the neighborhood that your dad lived in?
No.
Okay. What type of neighborhood was it?
It was a bad neighborhood. It was nice, peaceful.
Were there what I mean by is there like apartments there and everything?
Yes.
Okay. And did you live with your dad, Franklin Cologne?
Yes.
Now, did he live in that neighborhood with you?
Yes.
Do you remember how old Isaac is?
No, I do not.
Is he your age? Is he older?
I don't know.
Okay. Do you know if he was similar age to you?
No.
It's okay. Did Isaac have a little brother named Israel?
Yes.
Okay. Would you call him Izzy?
Yes.
All right. Was Izzy younger than you?
Yes.
Okay. Do you know how much younger Izzy was than you?
No.
Okay. And did you know Isaac and Izzy's mom, AJ?
No.
Okay. Did you know the lady who was shot in this case?
Yes.
Okay. And was that lady who was shot, was that Isaac and Izzy's mom?
Yes.
Had you ever seen Isaac and Izzy's mom before in the neighborhood when you lived there?
Yes.
How often would you see, or would you play with Isaac and Izzy a lot?
Yes.
Now, did you live in that neighborhood on the night that Isaac and Izzy's mom was shot?
Yes.
And now, the lady who shot Isaac and Izzy's mom, Susan, do you know her? Had you ever seen her before?
Yes.
Okay. Did she live in your neighborhood too?
Yes.
I'm going to show you a photograph. It's 1-1. You recognize that as Isaac and Izzy's mom?
Yeah.
I'm sorry. I wanted to make sure I wasn't missing anything. My bad.
Field?
Yes.
Okay. Do you remember what you did after you stopped playing in the field?
Yes.
What'd you do?
I went to go play basketball.
Okay. All right. And that basketball court, is that kind of near in the neighborhood there?
Yes.
All right. Now, at some point, did you ever remember seeing Isaac and Izzy's mom after you stopped playing in the field? Did you ever see Isaac and Izzy's mom walk over to Susan's house? Do you ever remember seeing Isaac and Izzy's mom walking over to the lady who shot her's house?
Yes.
Okay. Do you remember where you were when you saw her?
Yes.
All right. Where were you?
I was at the basketball hoop.
Okay. All right. And is that the street there in between some apartments?
Yes.
All right. And when you saw Isaac and Izzy's mom, can you tell like what she looked like when she was walking over there? Do you remember?
She looked mad.
She looked mad?
Yeah.
Do you remember if Isaac and Izzy's mom said anything while she was walking over to the lady who shot her house?
Yes.
All right. What do you remember her saying?
I remember her cursing.
Okay. Do you remember anything else specific she said?
No.
When she was going over there? Okay. Now, did you kind of, as Isaac and Izzy's mom walked over to the lady who shot her house, did you go somewhere else?
Yes, I started going to my house, like near my house.
Okay. All right. And did you see Isaac and Izzy's mom go up to the lady who shot her door?
Yes.
All right. Do you remember where you were when you saw that?
Yes. I was beside my house
Okay.
when it happened.
All right. So I want to show you some photographs. So just take eight. Were you in this area of this field of 8 and that we see in states 1-8 when you saw Isaac and Izzy's mom at the door?
Excuse me?
Were you in that general area when you saw Isaac and Izzy's mom at the door?
Yes.
Okay. Now, from where you were in that area, were you in that field area right there?
Yes.
All right. From where you were in the field, were you still able to see the door of the lady who, the door of the residence of the lady who shot Isaac and Izzy's mom?
Yes.
Okay. Were you able to see Isaac and Izzy's mom at the door?
Yes.
All right. What do you remember seeing when Isaac and Izzy's mom was at the door?
I remember her banging on the door.
All right. Isaac and Izzy's mom banging on the door?
Yes.
How is she banging? Can you describe that?
She was banging in a mad type of bang. She was banging like pretty hard.
Okay. Do you remember Isaac and Izzy's mom saying anything while she was
Yes.
banging on the door? What do you remember her saying?
I remember her saying, open up this door.
Okay. Do you remember Isaac and Izzy's mom cussing at all while she was at the door?
Yes.
Okay. Do you remember what she was saying?
Yes.
Okay. What was she saying?
She was saying the B word,
The B word?
and the F word.
Okay. Now, where was Isaac and Izzy's mom banging on the door?
Kind of in the middle.
In the middle?
Yes.
Okay. Did you ever see Isaac and Izzy's mom reach for the door handle?
No.
Did you ever hear Isaac and Izzy's mom say, "I'm going to kill you"?
No.
So then what do you remember happening after the banging on the door? Well, before I ask that question, did you see Isaac and Izzy's mom bang on anything else while she was
No.
at the door? So she's banging on the door. Does something happen next? What do you remember?
I remember hearing, after she banged on the door, I remember hearing a gunshot.
Mm-hmm. And then what happened after you heard the gunshot?
I saw Isaac's mom run and yelling, call 911.
What did you do when that happened?
I went to my dad. I ran to my dad, actually.
Okay. So you ran to your dad. Now, before, I want to go back. You said you saw Isaac and Izzy's mom walking over to the lady who shot her house, right?
Yes.
Before you saw Isaac and Izzy's mom walking over to the house, did you see either Isaac or Izzy run over to their house? To Isaac and Izzy's own house? Did you ever see them run back to their own house? Do you remember?
No.
It's okay. All right. Thank you very much. I appreciate it. Uriel.
Cross-examination.
Thank you. Hi, Uriel.
Hi.
My name is Morris. Remember we met before? I was on the video when we were talking to you. No, that's okay. That's okay. We're going to go nice and slow, okay? All right. You are currently 13 years old, right?
Excuse me one second. Do you want this picture up?
No, sir. No. Thank you. Okay. So back in June of last year, you were 12 years old, right?
Yes.
And you knew Susan, right?
Yes.
Okay. She was an older lady, right?
Yes.
Now, when Miss Owens, AJ, when she was walking over from her house to Miss Susan's house, AJ was really mad, wasn't she?
Yes.
She seemed really angry, right?
Yes.
Now, AJ first banged on Susan's sliding glass door, right?
I don't remember.
You don't remember? Okay. Do you remember It's been a long time, hasn't it? Over a year?
Yeah.
Do you remember giving a statement, like speaking to the police right after this happened?
Yes.
And do you remember the police asking you about everything that happened?
Yes.
Would reading a little part of that kind of help? Officially, it's called refresh your recollection. Would it help you remember what you said to law enforcement, what happened on that day?
Yes.
Your Honor, may I approach?
Sure. Excuse me, sir. You're going to read it to yourself, okay?
It's Adam, page 20, I'm sorry, Mr. Smith, page 24, lines 13 through 14, and page 25, lines 2 through 5.
Uriel, don't read it out loud. Just read it to yourself.
Is this the
okay?
deposition?
So this is the statement. May I approach, Your Honor?
Yes, sir.
So here, I'm going to show it to you, but just like the judge said, just the parts that I'm asking you to read, just read over to yourself. Do not read it out loud, okay? Okay, so we're going to start with page 24, and then read lines 11 through 17, okay? And let me know when you're done. Okay. Have you been able to kind of remember what you told the police back then?
Yes.
And you ever tell the police back then that AJ first banged on the sliding glass door?
Yes.
And now, after you read it, do you remember AJ first banging on the sliding glass door first?
Yes.
Okay. And then after that, you started banging on Miss Susan's regular door, right?
Yes.
And she was banging really hard, wasn't she?
Yeah, mad hard. Yes.
I'm sorry?
Hard. Yes.
And it was like bang, 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 hard, right?
Yes.
And she was doing it with her fist, right?
Yes.
And AJ was talking really loud as she was banging and banging and banging on that door, correct?
Yes.
Her tone was a loud one and a mad one, right?
Yes.
She was screaming, right?
Yes.
And where she was banging in the middle of the door, kind of like where the door handle is, right?
Objection, Your Honor, misrepresentation of the testimony.
Where was she
Hold on
banging?
1 second. Overrule the objection. You can answer the question if he knows.
And she was banging in the middle of the door, kind of like where the door handle is, correct?
No.
She wasn't?
She was banging in, not the middle where the door handle was, not like beside the door handle, just the middle.
Just the middle? Okay. But in that area, that's when she's banging with her fist, right?
Yes.
And I know you don't want to curse, so I'm going to mention some words, and then you let me know if these are the words that you said. I know you don't want to say it, I understand. But we have to know exactly the words she was using. She was using the words bitch, right?
Yes.
And fuck, right?
Yes.
And she was saying things like this bitch, right?
Yes.
You had seen arguments between Susan and AJ before this incident, right?
Yes.
When AJ would go down to Susan's house, AJ would tell Susan to stop effing with my kids and to leave or I'm going to fight you, right?
Yes.
And Susan would tell AJ to get off her property, right?
Yes.
On the day of the incident, you saw Izzy pass that no trespassing sign, right? That Miss Susan had.
Yes.
And Miss Susan told all of you to get off her property that day, right?
Yes.
And Isaac and Izzy told her to shut up and things of that nature on that day, right?
I don't remember.
You don't remember? Do you remember that day that you spoke to me and spoke to Miss Sizemore? She's sitting right over there.
No.
Remember you coming into like a building here in Ocala and speaking to us about what you know about the case? Do you remember that? It was a fancy name called a deposition. Do you remember that?
No.
No. Do you remember another time talking about the case with the lawyers that wasn't when you spoke to law enforcement, when you spoke to the police? Do you remember that?
Yes.
Okay. And do you remember that a court reporter was there, someone that was typing everything up?
Yes.
Okay, you do remember that. Do you remember if that was called a deposition?
No.
No, okay. And do you remember us talking about the things that we're talking about now?
Yes.
And would reading that kind of help you remember some of the stuff that we spoke about?
Yes.
Your Honor, may I approach?
Yes, sir.
Mr. Smith, this is page 18 of the deposition, lines 3 through 7, okay? Okay, Uriel, same thing. I'm going to show you the deposition, and don't read it out loud, just read it to yourself, okay? And then we'll talk about it, all right? Okay, page 18. And then lines 3 through 7, just let me know, okay? Let me know when you're done reading it, take your time. Okay, thank you. Does that help you remember what we spoke about?
Not really. No.
Not really? Do you remember that you told us that Isaac and Izzy told Miss Susan to shut up and things of that nature?
No.
No. But you did read that here, right? You did read it in the deposition that I just showed you, right?
Yes.
Okay. And you were several feet away, like 15 or so feet when this incident occurred, right?
Yes.
You were by the mailboxes, right?
Yes.
And AJ was right up on Susan's door, right?
Yes.
You could hear Miss Susan say, "Get out of my house," right?
No.
No? Israel, who you call Izzy, was near the tree that Susan had in the front of her property while AJ was banging on Susan's door. Is that right?
Yes.
And that would be the tree that's near the parking lot. Is that right?
Yes.
Okay. Isaac was near the mailboxes, right?
Yes.
Biggie was near the tree as well, right?
Yes.
None of them were at AJ's door, right?
Yes.
Okay. Israel, who you call Izzy, never got near Susan's door, right?
No.
Do you remember us talking about when everything was going on, what you heard Susan say to AJ? Do you remember us talking about that in the deposition that we spoke about before?
Wait, can you repeat it?
Do you remember you and I speaking about this incident and what Miss Susan was telling AJ when AJ was banging on the door? Do you remember that?
No.
Okay. Would showing you the deposition kind of help you remember again what we were talking about?
Yes.
Okay. Mr. Smith, specifically page 26 of the deposition, line 14 through 17. Okay. All right, same thing. I'm going to show it to you, and you just read it to yourself, and then we'll talk. Okay. All right, page 26, 14 through 17. Let me know when you're done. Okay. Are you done? Okay. All right, thanks. Do you remember Miss Susan telling AJ to get out of my house now? Yes, sir? Okay. All right. I appreciate your time. I know this is scary, but I really appreciate you being here. Thank you.
Any redirect?
Yes. Hey, Uriel, I want to ask you one more question. So I want to go back to when you see Isaac and Izzy's mom first walking over to the lady who shot her's house, okay? Remember that? When you saw Isaac and Izzy's mom walking over there?
Yes.
When you saw Isaac and Izzy's mom walking over there, did you see anything in Isaac and Izzy's mom's hands?
No.
No further questions.
See excused?
Yes, sir.
Thank you very much. If you can show him off the stand. Are you ready for our next witness?
Yes, Judge.
Aye.
Sheriff Gardner. Sheriff Gardner.
do you spell Jared? Is it Jared?
Jerrega.
Thank you.
Raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Have a seat, sir.
Can you please record?
Yes, sir.
Good morning, sir. Can you please state your name for the record?
Jareth Gardner,
And how old are you?
22.
They want to move your hair back so you can see you there. We can hear you good. Thank you. All right, so you're 22, sir. What do you do for a living?
I go to work
All right. Where do you work?
at a warehouse,
All right. What warehouse is that?
Amazon.
So, Mr. Gardner, I want to talk to you about a shooting incident that happened in June of last year, 2023. You remember that incident?
Yes, sir.
Now, did you live in the neighborhood where that incident took place?
Yes, sir.
All right. And did you know Isaac and Israel, or Izzy?
Yes, sir.
Okay. And did Isaac and Izzy live in the neighborhood with you?
Yes, sir.
All right. Now, who did you live with in that neighborhood back then?
With my mother.
All right. Do you still live in that neighborhood?
No, sir.
Did you also have a little brother who lived with you in that neighborhood?
Yes, sir.
What was his name?
Calix.
All right. Now, I want to talk about Isaac and Izzy. Had you ever seen Isaac and Izzy's mom before in the neighborhood?
Yes, sir.
Okay. And would you see Isaac and Izzy a lot in the neighborhood?
Yes, sir.
Do you know how old Isaac was approximately?
I believe he's 12, maybe. I don't know.
All right, around that age. All right. And was Izzy his little brother?
Yes, sir.
Do you know how much younger Izzy was than him?
He might have been like 10.
All right. So, I want to talk about the incident that happened last year on June 2nd, 2023. Were you at the house that day, sir?
Yes, sir.
Now, was there at any time later that evening that you became aware that something was going on?
Yes, sir.
How did you become aware something was happening?
My little brother came and told me.
All right, Caleb came and told you something?
Yes, sir.
Okay. And where were you when Caleb came up and talked to you?
In the living room.
All right. Of your house?
Yes, sir.
How was he acting?
I don't know.
You don't remember? Okay. All right. At some point, did you go outside of the house after Caleb had talked to you?
Yes, sir.
All right. And when you went outside the house, where were you?
In the street.
All right. I wonder, Your Honor, if I could please use the state's podium.
Are you ready for it to be on screen?
Yes, Judge. Mr. Gardner, I'm showing you states 1 through 3, states 1, 4, states 1, 5. Do you recognize kind of that general area of those photographs?
Yes, sir.
All right. In states 3, we see a basketball behind that black car. Is there a basketball hoop kind of somewhere in that area?
Yes, sir.
Okay. Is the basketball hoop, have the spread mark, is it kind of over here outside of the picture?
Yes, sir.
Okay. All right. So you go outside. Do you ever see Isaac and Israel when you go outside?
Yes, sir.
Okay. When you saw Isaac and Israel, how were they acting?
Like somebody had just messed with them.
Okay. And did you ever talk to them at all about what was going on, what was happening?
Yes, sir.
All right. And did you ever see Isaac or Israel where were you talking to Isaac and Israel first?
Under the basketball hoop.
Okay. So you were kind of over in this general area over here?
Yes, sir.
Okay. Did you ever see Isaac or Israel go over to their own house, Isaac and Israel's house?
Yes, sir.
Okay. After you talked to him? And then at some point, did you kind of leave the area of the basketball hoop and make your way over towards, this area of the parking lot street?
Yes, sir.
All right. Now, at some point, did you ever hear, and before I ask that question, I just want to make sure, the lady who shot Isaac and Israel's mom, Susan, have you ever seen her before?
Yes, sir.
Do you know where she lives?
Yes, sir.
Okay, I'm sure in States 5, does she live in this apartment right here?
Yes, sir.
All right. Now, did you ever hear, as you're kind of moving in this area of the parking lot area, street area, did you ever hear anything going on at Susan's house?
Yes, sir.
All right, if you could please explain to the jury what you heard.
I heard knocking.
Okay.
And a few words.
All right. So if you could please explain the knocking that you heard?
It was in 2 syllables. It was three knocks and 2 syllables.
Okay, and did the knocking, did it ever get louder as you're listening to it?
On the second knock, she got louder. Like the second syllable, she knocked a little bit louder.
All right. And when you say she, are you talking about Isaac? Well, I guess, were you able to actually see the door?
No, sir.
Okay, so you heard some knocks. All right, and now could you hear anything at that point when you're also hearing anything besides the knocks? Did you hear anybody saying anything at that point?
I heard her say, "Come outside."
Okay. And you said her, are you talking about Isaac and Izzy's mom?
Yes, sir.
All right. Did you also hear anything else? Any cuss words used by Isaac and Izzy's mom?
Yes, sir.
All right. What did you hear?
The B word.
Okay. All right. So you said you heard "come outside." You heard the B word. At any time, did you ever hear Isaac and Izzy's mom say, "I'm going to kill you"?
No, sir.
Now, at some point, did a gunshot happen?
Yeah. Yes, sir.
If you could explain kind of what you saw as that was going on.
Can you say that again?
Yeah. So how did you become aware a gunshot happened?
I heard it.
All right. And where were you? Do you remember?
I believe I was still crossing the street.
Okay. When you say crossing the street, are you kind of in this general area though, where we're seeing stage 5?
Yes, sir.
Did you ever see Isaac and Izzy's mom come out from the defendant's patio?
Yes, sir.
All right. Do you know what happened to where she went?
She ran from the front door and collapsed by the tree.
All right. I have no further questions for this witness.
Cross-examination.
Yes, sir, may I inquire?
Yes, ma'am.
Yes.
Good morning. Now, you know Miss Owens' children, correct?
Yes, ma'am.
That's Israel and Isaac?
Yes, ma'am.
And you consider yourself like a big brother to them?
Yes, ma'am.
So I want to talk to you about the day of this incident. So you were outside by the basketball hoop before the shooting, right?
Yes, ma'am.
And Israel and Isaac were with you?
Yes, ma'am.
And they told you about what had happened with them over at Susan's house, right?
Yes, ma'am.
And one of the kids said, "Go and get AJ," right?
Mm-hmm.
Is that a yes?
Yes, ma'am.
And you saw Miss Owens walk across the street to Susan's house, right?
No, ma'am.
Had Miss Owens already crossed the street by the time you saw her?
Yes, ma'am.
Yes. Miss Owens seemed frustrated, right?
No, ma'am. I didn't see.
Do you recall giving a deposition in this case?
Yes, ma'am.
Would seeing a copy of your deposition refresh your recollection as to whether or not you said Miss Owens was frustrated?
I believe I said, from my perspective, she might have been like just, from my thought, she may be frustrated.
Now you heard Miss Owens knocking like boom, 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 right?
I heard her knock normal at first.
Do you remember giving a statement to law enforcement?
Yes, ma'am.
Would seeing a copy of your statement to law enforcement refresh your recollection as to what you specifically said regarding the knocking?
Yeah, she knocked in 2 syllables 3 times.
Do you remember Miss Owens knocking like boom, boom, boom?
I remember her knocking louder the second time. Yes.
Okay. So you heard Miss Owens knocking again a second time, but louder. Is that
Yes,
right?
ma'am.
And that's when you heard the gunshot go off?
Yes, ma'am.
You heard Miss Owens say, "Bitch, open the door," right?
No.
Would seeing a copy of your deposition refresh your recollection as to what you heard Miss Owens say?
I believe I heard her say, "Come outside, bitch."
Mr. Smith, I'm referring to the witness's deposition, page 15, lines 17 through 19.
Okay.
During your deposition, you were asked the following question and gave the following answer.
Your Honor, I would ask that the witness be able to read the deposition.
Certainly, you can show it to them.
Okay, Evan?
Sure.
So I'm going to let you see your deposition and I'll let you read this to yourself, okay? Beginning here and ending with lines 19, just let me know when you're ready. You finished? yes?
Yes, ma'am.
You heard Miss Owens say, bitch, open the door, right?
No, ma'am.
All right. So during your deposition, you were asked the following question and you gave the following answer. Question. Okay, but you heard AJ say, open the door, and you may have heard her say, bitch.
Yes,
Answer.
ma'am.
Yeah, like, bitch, open the door.
Hold on
Miss
1 second.
Owens' demeanor
Excuse me,
was-
1 second. Approach.
Miss Owens' demeanor was like somebody just messed with her kids, right?
I don't know. I didn't see.
I'm sorry, say that again?
I didn't see.
Okay. Would seeing a copy of your deposition refresh your memory as to what you said regarding Miss Owens' demeanor on that night?
I don't have a deposition to look at.
For Mr. Smith, I'm referring to the witness's deposition, page 16, lines 22 through 24. May I approach the witness, Judge?
Sure.
Here. Okay, finished? During your deposition, were you asked the following question and did you give the following answer? Question. What was AJ's demeanor like when she was knocking on the door? Answer. Like somebody had just messed with her little kids.
Yes, that's what I had thought.
Now, you were approaching Miss Lawrence's door when Miss Owens began knocking, right?
Yes, ma'am.
And you went towards Susan's house because you felt like an altercation was going to happen, right?
No, ma'am.
Do you remember giving a statement to law enforcement in this case?
Yes, ma'am.
Was seeing a copy of that statement refresh your memory as to what you told them about that?
Yes, ma'am.
Mr. Smith, I'm referring to the witness's interview, page 11, lines 1 through 8. May I approach the witness, Judge?
Do you have an extra copy
Do I have an extra copy
of that?
Sure do not. Do you want to see it first?
Sure.
May I approach?
Sure.
Right, so I'm going to have you read this all the way down to line 8 and just let me know when you're finished. Are you good? Okay, so yes?
Yes, ma'am.
Do you remember the detective asking you the following question and you giving the following answer? Question, and what made you think that there was going to be an altercation? Was something being said or did you hear something? Answer, I don't know, I could just off the energy. Question, off the energy? Answer, I felt like an altercation was going to happen. Do you remember giving that answer?
Yes, ma'am.
Thank you, I don't have any other questions.
Ready to redirect?
No, Your Honor.
This witness excused.
Yes, he's excused.
Thank you, sir. Have a nice day. Can I ask everyone to approach real quick?
Nothing but the truth, so be God.
Yes.
Go ahead.
Morning.
Good morning. Is it still morning? Good morning.
Would you please introduce yourself to the jury, ma'am?
My name is Yvonne Costa.
What do you do for a living?
I am retired
Congratulations.
and very proud of it.
Where did you work before you retired?
Marion Senior Services.
For about how long did you work there?
16 years.
All right. I'm going to direct your attention to June 2nd of 2023. Where were you living then?
The address,
Yes.
1662 Southwest 107th Lane, apartment number 4 in Ocala.
Was that a quadplex type
Yes.
structure?
Yes,
And meaning there were 4 different residences in the same building?
yes,
You said you lived in unit 4?
yes,
Showing you photograph 2 of state 1. You recognize that aerial view?
yes.
There we go. All right. Where would your residence be in this quadplex? This is the building you live in, right?
Yeah.
Okay. Were you in the front or were you in the back?
I was in the back.
Okay. On this side, the same side where it says defendant's residence?
Yes,
When did you move into that unit?
the beginning of December of 2022.
Okay. So you
Yeah.
lived there about 6, 7 months or so by the time
Yes,
the shooting happened?
yes.
Understood. Where did you live before that?
Two
Now,
buildings, 2 buildings away from where that apartment is.
Do you know a woman named Susan Lorincz?
Yes, I
Do
do.
you see her here in court today?
Yes, I do.
Can you please point her out and tell me what she's wearing?
She's wearing a purple jacket.
Your Honor, may the record reflect the witnesses identified the defendant.
It also reflect.
So if I am facing your front door, would her residence be to the right or to the left?
Left.
Did you share a common wall in
Yes,
the residence? What was your relationship with the defendant? Were you really close friends? Were you acquaintances? She lived next to you?
yeah, she lived next to me.
Did you hang out and socialize with her a lot?
No,
Can you estimate about how many times you've even had any interaction with her?
maybe 10 times in passing. Hi, bye, have a good day.
Did you know Miss Owens, Miss Ajike Owens, the
Yes.
victim in this case?
Yes,
What was your relationship with her?
I only saw her 2 or 3 times, and she lived across the street.
Did you know Miss Owens' children?
I knew one of them fairly well.
Which one was that? What was
Her oldest son,
you know his name?
Isaac.
Okay. You said you knew him rather well. Did he actually come to your apartment at one point?
Yeah, he came to my apartment twice and asked to use my telephone.
Did you let him?
Oh, yeah.
Okay, everything worked out fine?
Yes,
Objection relevance.
So ruled. Good.
Was there a field next to your house, your
Yes.
structure that the children played in?
yes,
If the children were playing in that field, were you able to see them from your vantage point in your house?
yes.
Were they sometimes loud?
Oh, yes,
Did they often have adult supervision there? with the
yes.
children? Is it fair to say that the defendant would express displeasure with the children?
Objection, relevance, improper character.
That's sustained.
Did the defendant at some point have a no trespassing sign near the entrance to her residence?
There was a few no trespassing signs, like at the property line, that I thought my landlord put up.
Let me direct your attention to the day of the shooting, June 2nd of 2023. That evening, where were you located when all this was going on?
In my apartment.
And at some point, did you hear some arguing?
Yes,
About how long before the actual shooting did you hear this arguing?
between 5, maybe 10 minutes.
Could you tell who was involved in this argument?
I recognized Susan's voice, but I didn't recognize the other voice, and I couldn't make out what they were saying.
Okay. At any time during this argument, did you hear a door slam?
Yes, yes.
After you heard the door slam, what was the next thing you heard that drew your attention?
My wall in between our 2 apartments started shaking and like pounding on the wall. And it really scared me.
Okay. How long after you heard the door slam did you hear that pounding?
Very shortly, within a few minutes.
How would you describe the pounding?
It was very loud, and it scared me because the wall was shaking, and yeah.
Okay. That's okay. Do you remember like the sequence of the bangs? Was it just constant banging, or was it a set of bangs, a pause, and a set of bangs?
Yes.
Do you remember that?
There was a pause and then more banging.
Do you remember about how many times you heard banging?
Just those, you know, the once, short break, and more.
Do you remember about how many bangs were in the first set?
Oh, it was a lot.
Okay.
A
And
lot.
what about the second set?
A lot.
When you heard the banging, what was your first thought of who was causing that?
I thought Susan was banging on the wall.
Did you later come to learn that that was not the case?
Yes.
Okay. And so the jury's not misled. Did you learn that that was Miss Owens actually banging?
When I mentioned that she was banging on the wall, one of my neighbors said,
Objection, hearsay.
That's sustained. Let's move along.
You can't know what other people said.
okay,
Hold on. Just move to the next question.
Thank you, Your Honor.
You're welcome.
Did you hear any voices raised during the pounding?
yes.
You just couldn't know what was said.
Right.
Understood. After that banging, did you hear another sound?
I heard a pop,
And what did you hear after that pop?
people screaming.
After you heard the pop and you heard people screaming, what did you do?
Just people screaming.
What did you do though?
I grabbed my phone, ran into my bedroom, which was the farthest part from the front door. My cats all ran under the bed because they heard it, and I called 911.
So you called 911 after you heard the pop,
Yes.
and obviously you later learned that pop was a gunshot.
Yes.
Did you recognize it as a gunshot when you heard it?
Not at first until I heard screaming and my cats running under the bed. Then I knew what it was.
And then
Exactly. That was like within seconds.
And at that point you called 911.
Yes.
And did law enforcement arrive?
Yes.
Thank you, ma'am. No other questions, Your Honor.
You're welcome.
Cross-examination, please.
Yes.
Yes, ma'am.
Good morning.
Hi, good morning.
That neighborhood back in December of 2022?
I've been in that neighborhood for like 15 years before I moved into the building I'm in now.
Okay. And you lived alone?
Yes.
And you refer to that neighborhood as the hood?
Yes.
The landlords rent to some unsavory people?
Yes.
And
Yeah.
there have been some shootings in that neighborhood before, right?
Objection,
Yes.
Your Honor. Relevance.
Sustained.
The unit that you lived in back in June of 2023, that shared a wall with Susan Lorincz, right?
Yes.
So if I'm standing and I'm facing Susan Lawrence's door, your house would have been to the right,
Yes, ma'am.
and you called 911 on the night of this incident.
Yes.
So the kids were playing in the field that evening, right?
I believe so. Yes.
And they were being very loud.
Oh, yeah.
And you heard what sounded like two people with raised voices, right?
Yes.
And then you heard a door slam.
Yes.
And then you heard banging on the wall, right?
Yes.
And that banging was really, really loud. right?
Yes.
So loud that it caused your cats to run under the bed or run off.
They didn't run under the bed until they heard the pop.
Okay. So you heard this banging and then the banging stopped, right?
Yes. Very briefly.
And then you heard it again, but only worse.
I can't say it was worse. No, about the same.
Do you remember giving a deposition in this case?
Yes.
Would seeing a copy of your deposition refresh your memory as to what you heard?
Yeah.
Okay. For Mr. Buxman, I'm referring to the witness's deposition, page 19.
I don't have my glasses.
Okay.
They're in my purse out there.
Well, you're probably gonna have to read it. Is there any way we can take a break so she can get her glasses?
Yes, ma'am. Does she need to go in her purse? And get it? Okay.
Should I go get them?
Yeah, you can get off the stand, go get your stuff out of your purse and come back. Thank you.
Yeah, please. Thank you.
Page 19, lines 1.
Guys, I still have my eyes on the actual
Yes, ma'am.
live feed and nothing yet. So we're continuing with our replaying day
Yes, ma'am.
To 7.
But read it to yourself,
1.
okay?
Okay.
You finished?
Yes.
So the banging stopped, right?
Mhm.
Is that a yes?
Yes.
And then you heard it again, only worse.
Yes.
Right? And then you heard a pop.
Yes.
Now the banging was so hard it was shaking the walls in your house, right?
Yes.
And you were scared.
Oh, yes.
And while this banging was happening, you heard voices, right?
Mhm.
Is that a
Yes. I'm sorry.
That's okay. And the voices were loud.
Very loud.
The voices were aggressive.
Yes.
Like when the sheriff's office knocks on a front door real loud, right? Is that a
Yes.
yes? The voice was really loud and deep.
Yes.
The voice sounded like when someone gets really mad and really wants to scream, right?
Yes.
Guttural and deep.
Yes.
And it sounded like it was coming from outside, right?
Yes.
I don't have any other questions. Thank you.
Can you redirect?
No, Your Honor.
She excused?
Yes, sir.
Thank you, ma'am. Have a nice day.
Oh, thank you. You too.
Okay. Ladies and gentlemen, what we're going to do is take our lunch break as soon as we have this witness excused. Your lunch is here. I'll ask you to put down your notebooks. Hold on. Ma'am, if you can just.
It was like a boom, like, yes.
Did you
Friend, we're doing,
have your house after the field?
yes.
All right. What were you doing inside the house?
Me and my BYN,
How old are you, London?
12.
Can you
Need to either get closer to the mic or speak a little louder, okay? Thank you.
can you please spell London?
LONDYN,
How old are you, London?
12,
What grade are you in?
6th,
What's your favorite subject in school?
math,
Yeah. You like to do things outside of school?
yeah.
What's your favorite thing to do outside of school?
Play football,
So I want to ask you if you know some people. Do you live in a neighborhood called Quill Run?
yes,
All right. And did you used to live next to some people named Isaac and Israel?
yes.
All right. And do you know how old Isaac was approximately?
11 or 12,
Okay. And was Israel Isaac's little brother?
yes.
All right. Do you know how old Israel was, if you remember?
8 or 9,
And did you used to call Israel Izzy?
yes,
And did you know Isaac and Israel's mom, Ajike?
yes,
Did she live next to you in the
yes,
neighborhood?
yes,
Did Ajike have any other children there besides Isaac and Israel that lived next to you?
yes.
Who were those children?
Africa and her son, I forgot his name,
It's okay. And how old, do you know how old Africa was approximately?
6 or 7.
And do you know the other son? Do you know how old youngest son?
I don't know how old he was.
All right, was he younger than Africa?
Yes,
Okay. And this Titus, was that his name? Is that ring?
yes,
Okay. Now, there was a shooting that happened in your neighborhood, and you're aware of that shooting, right?
yes,
You know why we're here today?
yes,
Okay. Well, I want to ask you about the day that the shooting happened last year in June. Okay. So before the shooting happened, were you playing in a field in the neighborhood?
yes,
All right. I want to show you a picture, London. State 7. You see that field kind of over here? There you go. Were you kind of y'all playing over in this field over here?
yes,
At some point after playing in the field, did you ever see any roller skates or a tablet left anywhere?
yes.
Do you remember where they were left?
Like by the tree, like where that sign, that no trespassing sign is, like around there.
Okay. So kind of like around here?
Yeah,
All right. And that's the tree you're talking about right here?
yes, sir.
All right. So you saw it left over there?
Yes,
All right. Did you leave the field?
yes,
All right. Where did you go inside your house after the field?
yes.
All right. What were you doing inside the house?
Me and my best friend were doing each other's makeup.
And at some point, did you hear a noise or something that startled you?
Yes,
All right. And what did you hear?
it was like a boom, but like we live next to a road, so we thought like maybe a car hit a tree or something like that.
And did you go to your door? Did you hear anything about your door?
Yes, we heard knocking on our door.
Ooh, guys. My anxiety is up. Oh my God. Okay, we're back in real time now. Maybe the jury is back. The judge is not here saying they have a question, so I'm going to assume the jury might be back. Girl, did you see the sheriff with the business in the front, party in the back hairstyle, the mullet? Girl, can you still get those? I guess you can. I'm stressed too. Thank you so much. Call me Rose. I appreciate that. You guys are awesome. The sheriff had a Billy Ray Cyrus. She had an old school Billy Ray Cyrus.
I'll get that.
I can text Rich.
Look at Bonnie, Ponytail, and Creepy Yoki.
I'll call Rich.
Bobby. Look, the sheriff's deputy over there.
Rich isn't
You see how many police they got? Okay. They look at all the sheriff. So I don't know if this is they have baby.
I'll send Rich a text.
They got a lot of law enforcement in there. I don't know. It's going to be okay, family. One way or the other, it's going to be just fine. They got a lot of law enforcement for this verdict. So, I mean, do they expect Susan's going on the run or they expect people going to show out? What's T? I know my heart is beating fast. Well, based on how Susan behaved, they might be getting ready to take her into custody, as quiet as it's kept, because I mean, she already is in custody of the county, but based on how she behaved when they were taking her out of the interrogation room, when things changed, who knows? But these, it's okay, Mom. It is okay. It's gonna be okay. It's going to be okay no matter what. I mean, at the end of the day, Susan has to live with the fact that she killed somebody. So that's not a question. This is not a murder mystery. We know that Susan killed Ajike Owens. You know what I mean? We know, everybody knows.
Okay.
You see the detective right back there? He's right back. The one who initially questioned her, he's there. Guys, 80% of you say that the prosecution delivered the case. Well, 79%. So I think she's getting ready to get remanded into custody, girl, because they are thick up in that courtroom. Now, they could be prepped because they think that there could be a negative reaction in the gallery, and that's always a possibility. But they mob up when they know that someone is getting ready to be remanded into the custody. So it's quite possible they have all the people because she's going to be asked to stand handcuffed and she's gone if she's convicted, right? So we don't know. It's coming soon, though. Right. She's been difficult and non-compliant before, so we're going to see.
All right. Court's now back in session.
Have a seat, everybody. All right, we're going to go back on the record on the state of Florida versus Susan Lorincz. What we're going to do is we'll bring the jurors back in. Before we take the verdict from them, I'm going to read the jurors their instructions upon discharge, which gives the jurors their rights. I hope everyone will respect that. And remind everybody to keep the same calm demeanor we've had the whole trial. Again, I appreciate it. The jurors will pass a note to the bailiff and to me. The clerk ultimately will publish the verdict. Either side wants the jurors polled. Again, we will poll them by number. Okay, and they have their numbers. Let's bring them in. Yes, ma'am. Okay. Yeah. Ladies and gentlemen, it's my understanding you have reached a verdict in this case. Is that correct? What I'm going to read to you is the last instruction. This regards you as jurors. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Can you please hand the verdict to the bailiff, please? And have the clerk read the verdict.
Verdict as to count one. We, the jury, find as to count one of the charge. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally used a firearm? Yes. So say we all, dated the 16th day of August, 2024.
Does either side wish to poll the jurors to be polled?
Yes, sir.
Madam Clerk, please poll the jurors by number only.
Juror number one, is this your verdict? Juror number two, is this your verdict? Yes. Juror number three, is this your verdict?
Yes.
Juror number four, is this your verdict? Yes. Juror number five, is this your verdict? Yes. Juror number six, is this your verdict?
Yes.
Ladies and gentlemen of the jury, if you can go back to the jury room, please wait there and I'll discharge you in a few moments, okay?
Baby. Bye, Susan.
Also,
Bye, Susan.
oh wait, I don't think I dated that. Let me do that one back.
Ooh, Jesus.
Ms. Lawrence, the jury has found that you're guilty of manslaughter with a firearm. You're going to be adjudicated guilty of that offense. I assume that sentencing will be at a later date. Is that correct?
That's correct, Judge.
Are you requesting a pre-sentence investigation?
Yes, sir.
What I'm going to do is have the Department of Corrections prepare a pre-sentence investigation. I'll continue this case. I'll put it all the way to the November docket, although I expect us to be sentenced long before that. I'm just putting us far enough away to get everything done. So when we get the PSI done, then please contact my office. We'll set a sentencing. Ms. Lawrence, you're going to be held in custody of the Marion County Jail without bond until that time, okay? Thank you and good luck to you.
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
Bye, Susan. Look, let me tell you something.
I understand. We also, okay? We will be in recess.
Yes. Okay. Well. You know, look, I'm not even, look, it's by Susan. Look, at the end of the day, I was nervous, but I wasn't scared. I promise you. I felt that justice was going to prevail. I feel like for reasonable and responsible, educated gun owners, it was a bad day for gun owners because there are a lot of people who take their privilege seriously, and we can't have this type of behavior. It's not conducive to a civil society. To not be able to have a reasonable expectation to knock on a door, to protect your children and all of the things, and not be afraid to lose your life because you knock on someone's door. Also, as a parent and a mother, are you kidding me? This had a lot of ramifications and implications regarding a mother's ability to be able to protect their children, as two adults, neighbors, to be able to have a civil conversation, even if it's heated, and also to have a reasonable expectation to knock on a fucking door. Okay. So I'm so glad that the people of Marion County did the right thing and observed the law, because also, as someone who may own a firearm, if people are going to be running around like it's the damn wild, wild west, that makes it bad for everybody. It makes it very unsafe. It makes it unpredictable. It makes it not reasonable out here. So I'm so happy and grateful that the right answer came. And to me, I'm sorry, like I felt a little bit put upon as a Black mom, as a Black woman, that we're so scary and beastly that people have to be afraid of us. And that's not the truth. I'm walking away with this with some lessons learned. I'm not engaging with crazy people. Somebody's crazy, I'm gonna let them be crazy, and I'm gonna let you talk to the people you like to talk about to, which is the police, because you don't like to talk to me. So I'm gonna let you talk to the police, and I'm gonna use the police just like you use the police, because I will not be talking to you. You know what I'm saying? That's my takeaway. Because this is a scary case. These kids don't have a mom. And this lady is so hurt behind losing her child. And these kids have to grow up knowing that this like neighborhood drama resulted in the death of their mom, which was definitely not their fault. But this was some beef between a grown ass woman and a bunch of fucking kids, and probably a lady coming home from work trying to raise her children and having to deal with some damn drama and mess. I don't blame her. Last thing I'd want to do is to have to deal with that shit too. Like, sis, what is your problem? Can the kids play in peace? Anyway, I'm so grateful. I'm so glad. Susan, it's a wrap, boo. And she's just going to have to deal with what she's going to have to deal with. So that's kind of, we'll talk about it. Clearly the prosecution brought it. You guys voted almost 80% that the prosecution did what they needed to do, and they did what they needed to do. So the law was observed, and all of the things. So you guys are troopers. This was a fun week of court watching and justice for AJ Owens, justice for these children in the neighborhood of, what was it called? Quail Run neighborhood. You can't do this. This is some stupid behavior. And to the defense team of Bobby, Creepy, and Ponytail, nice try. So I don't know, you guys, I'm just clicking on your comments, but I'm drained. I'm very grateful. Thank you. I will give Farrah her tip. Thank you so much, Soul Power. Call me. You know, Farrah sat beside me here all morning. So, ooh. And I'm gonna tell you guys, this is a full disclosure. I have told Farrah on many occasions, like between me and her dad, don't ever put me in a position where I gotta hurt somebody because of you. Like you know, and I'm not talking about the kids in Florida. I'm just talking about as an aside, because as a parent, I'm coming for that ass. You know what I'm saying? Like but don't think wisely how you behave out here, because you know, like this is scary. It's scary. You know, it's very scary. But I'm so grateful that AJ got justice. So the verdict was guilty. Susan's going to jail. It was by Susan. So the first is that my that's my phone out there. The first indication to me that we got, we can watch it again. Hold on. Or we can run it back. Susan, the scowl. Let's run it back, okay? Did you notice the demeanor? Susan tightened up right away. All that fakery emotion that she had, she got real tight. Sis ain't going nowhere. Even if they give her whatever they decide to give her, whatever they give her, even give her 10 years, she's done. She's done. The first indication to me, at first I was kind of like, are they there for the family or what? I mean, you know, they do that, right? But also, if you pay attention in criminal trials, when they're getting ready to remand someone in custody, they start, you know, you'll notice the sheriffs and everything. If it's a highly contemptuous situation, but the family has been very dignified, the whole entire time. I didn't expect any kind of you know what I mean? Like, we're not even going to go there with that. My first thought was that they were there for the defendant, that they were going to be taking her into custody, and they were just exercising precautions based on maybe her demeanor. Okay. You guys are sweet. Thank you, Pen Pal 50. I will let Boo Boo know. Pen pal 50 cents, your $10, baby. Farrah's asleep in her chair, y'all. Her office chair must be too comfortable. Sis fell asleep. She's been in here with me all day. I will get that to her. Thank you, pen pal. I appreciate both of y'all. Let me so you guys can see. So they started mobbing up in the courtroom, the sheriff's department, and another indication to me is that her sheriff, who's kind of been with her the whole entire time, had her hand on her gun, and she was staying right behind her. And then they had another sheriff's deputy right behind her. And just notice when you watch criminal proceedings, like those postures of the of law enforcement. I mean, they do kind of that stuff anyway, but I don't know. To me, I was thinking it was going to be a guilty, and I'm so glad that they followed the law. Anyway, we'll replay it and I'm gonna let you know. Just notice how she tightens up. She that scowl came back. Girl, look at Billy. Look at that business in the front, party in the back. Yes. She was watching the chat and everything. I was a little nervous, but I really feel like this judge was such a good judge. I think that I do feel like the judge really is instrumental in the flow of things, and he did such a good job. He's really but we got to keep our eye on the sentencing.
You guys call Adam?
I can text Rich.
I'm gonna just say this too, and you guys may feel different. I feel like Susan, for some reason, felt like she was better than the neighborhood. Sis, you part of the neighborhood. She must have forgot that she was part of the neighborhood too. I feel like she thought she was better than the neighborhood. She got these lawyers to come in here and talk down on the neighborhood that you lived in before some of those people even got there. How are you better than the neighborhood when you're part of the neighborhood too? And you're sitting up here, a grown ass woman, and arguing with a bunch of churn. People gonna learn to stop messing with people's children. Okay. There is nothing that justifies improperly using a weapon, because that is offensive to people who actually really take their privilege to have a weapon seriously. And people like her make it difficult for people to be able to exercise their right to have a firearm. People like her call that into question. Today, that is a confirmation that you can't mess around with these firearms and just do what you want. It's a privilege, and you have to observe the law if you're going to have a firearm. You want to come out here and be okay corral, you're going to be dealt with. Okay? That's number one. Yes, we're going to where they're reading it again. We're going through it one more time, and then we'll let y'all go. They're bringing the jury back in. The suspense was a killer. Whew. Okay. I bet you everybody's rerunning this right now. Hold on, it's coming. How in the world was she found guilty? She was found guilty by a jury of her peers who looked at the law and went on facts versus feelings. And sis is on her way to the penitentiary. She's been remanded back to the sheriff's department, and she will be sentenced very soon. That's how she got found guilty by a jury of her peers on today.
All right. Court's now back in session.
Have a seat, everybody. All right, we're going to go back on the record on the state of Florida versus Susan Lorincz. What we're going to do is we'll bring the jurors back in. Before we take the verdict from them, I'm going to read the jurors their instructions upon discharge, which gives the jurors their rights. I hope everyone will respect that, and remind everybody to keep the same calm demeanor.
Fine as to count one of the charge.
Clerk, read the verdict.
Verdict as to count one. We, the jury, find as to count one of the charge. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally used a firearm? Yes. So say we all, dated the 16th day of August, 2024.
Does either side wish to poll the jurors to be polled?
Yes, sir.
Madam Clerk, please poll the jurors by number only.
Juror number one, is this your verdict? Juror number two, is this your verdict?
Yes.
Juror number three, is this your verdict?
Yes.
Juror number four, is this your verdict?
Yes.
Juror number five, is this your verdict?
Yes.
Juror number six, is this your verdict?
Yes.
Ladies and gentlemen of the jury, if you can go back to the jury room, please wait there and I'll discharge you in a few moments, okay? Here we go. Also, here's the last one. Oh, wait, I don't think I dated that. Let me get that one back. Ms. Lawrence, the jury has found you guilty of manslaughter with a firearm. You're going to be adjudicated guilty of that offense. I assume that sentencing will be at a later date. Is that correct?
That's correct, Judge.
Are you requesting a pre-sentence investigation?
Yes, sir.
Look at her demeanor. Before they read the verdict, well, she was still looking stoic.
Speak with anyone about your deliberations verdict or your from the meeting to you. Did you please hand the verdict to the bailiff, please? I'll have the clerk read the verdict.
Verdict as to count one. We, the jury, find as to count one of the charge. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally used a firearm? Yes. So say we all, dated the 16th day of August, 2024.
Does either side wish to poll the jurors to be polled?
Yes, sir.
Madam Clerk, please poll the jurors by number only.
Juror number one, is this your verdict? Juror number two, is this your verdict?
Yes.
Juror number three, is this your verdict?
Yes.
Juror number four, is this your verdict?
Yes.
Juror number five, is this your verdict?
Yes.
Juror number six, is this your verdict?
Yes.
Ladies and gentlemen of the jury, if you can go back to the jury room, please wait there and I'll discharge you in a few moments, okay?
I'm hoping there were gun owners. I don't know. Parents, reasonable people, law-abiding citizens, people that can read, people that can have a basic understanding. All of the things showed up and delivered a verdict that provided justice for this grieving family. A lady who was just out, like, ma'am called for her, like, she called for AJ. AJ came through, and I bet you she wishes she made a different decision now. Her life is forever. She's a convicted felon now, murderer. Okay, murderer, convicted of manslaughter with a firearm. Won't be able to rent an apartment. All of the things, Susan. And she might not ever need to, because she could get up to 30 years. We'll see what the judge does. He seems to be a nice guy. I don't know what he's going to do, if he's going to split it down the middle or he's going to give her the max based on the children who have to deal with the max life sentence of, having to have seen and suffered watching their mom die in their defense. So I don't know. Anyway, guys, I'm going to let y'all go. It's been a long day. I hope you guys have a wonderful rest of the day. I'll be back around probably tonight. So anyway, we'll talk about this. Maybe we'll open the phone lines if you guys want to talk about it, open the call in. But I'm going to take a rest. I'm going to rest my brain for a bit. And I really enjoyed this week of court watching with you guys. This was, it was really nice to see justice prevail for this family and for the community and responsible gun ownership and all of the things. And yeah. Okay, guys, I'm going to let you guys go. You guys take care. Have a great day. And I will catch you guys later on these YouTube streets.